Hello there. I am trying a new setup tonight. I got a new laptop, so I also got a new monitor, and so I'm assuming you can all hear me just fine. Okay, great. And I should say this that if for whatever reason, like in the middle of a class, like I disappear or I crash or whatever, just sit tight and wait like up to 5 minutes or so. And if I for some reason cannot log on at all, I'll email you through Canvas. But if I do disappear or crash, just sit tight. Once in a while, things happen. So just wanted to throw that out there. But hopefully that won't happen tonight. The one caveat is that I was having some Wi-Fi issues with this new setup. So it seemed to be, I think I got it ironed out, but in case I freeze or whatever, please let me know if I'm freezing or delaying or whatever, and I can switch to another room with my work laptop. I've been doing this class on my work laptop the past few weeks. So anyway, I just wanted to throw that out there. Um, okay, so tentatively, the midterm is next week, and we'll see what we get along with here. What's if I had to predict what's going to happen is we won't quite finish the contract law chapter, but we'll finish it up next week, and then the midterm will be the second half of the class. So what we'll do is we'll meet for like half a class, and I'll tie up any loose ends, and then we'll have like a break, and then you'll have the rest of the class to take the exam. But let's just see how far along we get tonight. Are there any questions about anything? Okay, so hold on, just a sec. Okay, let me. It's better. Um, okay. So you may remember I introduced this topic last week. Oh, hold on, I'm not on the right chapter. There we go. Okay. So I introduced this topic last week kind of with a bit of dread because this is my least favorite chapter to go over. This is the chapter that is brand new since the 16th edition. And so the ERE is putting more emphasis on disclosures. But as I also mentioned last time, I think the problem, I mean, if you asked me, should any of these disclosures not be given? My answer would be, well, no, they each serve a value. It's not useless information or anything, and it's something that home buyers should know. But the problem is the cumulative impact of so many disclosures makes the home buying process overwhelming. And I think people don't read this stuff, except for who? Who reads the stuff? Nobody reads this except anybody? Yeah, Devin.
Engineers.
Engineers read it. Nobody else does. So, but the problem is you should be reading all of this, but most people don't. I think if you were only given 5 disclosures to read, you'd be more likely to read it. But if you're given like 20, you just tune it out. So what I'm going to try to do is go over each of the disclosures rather quickly and try to explain like what is the point of this disclosure. So if you're working with clients, you're going to dump on them this big old packet of disclosures if you're working with buyers, let's say. And, I think you should give your clients the space to take as much time to review this as they want. And again, ask them, do they want it hard copy or soft copy? But also, I think you should be familiar with the basics of each form so that if your client has a question like, what does this mean? You know the basics of what to tell them. And then I will go through and add my own opinion as to which ones are really important and which ones aren't, I think, as important. Okay. So the very first one, I don't think is that important. Okay. The reason being, it's basically a catch-all thing. It's especially not important if you live like in an urbanized suburban area like most of us do. Now, if you lived up in the Santa Cruz Mountains or you lived up in, the Sierras and the foothills, something like that, especially where there's more fire damage or flood danger, this is more important. But basically what this form tells you is the home you're buying in any kind of particular danger zone for natural hazards, such as flooding. Okay. And I think that's important to know because floods are probably going to become more and more common with climate change. And so you may want to get flood insurance. So someone should know that. Seismic. So this actually tells the buyer where the property is compared to earthquake faults. That to me is sort of like general information that I think any person could look up on their own, but it's contained in this disclosure. Are you near a dam? Like if there was a dam nearby that collapsed, would you be affected by the flooding? And yeah, wildfire risk, et cetera. So those are just some things, that I think a lot of this should be obvious to a reasonable person, but it's a disclosure, so you're supposed to give it to your clients. Okay. Other mandatory disclosures, the advisability of getting title insurance. So I can tell you if a lender is involved in the transaction, meaning the buyer's not paying cash, the lender will insist on title insurance. So that advisory is not really necessary if there's a lender, but if there's not a lender, the client should still get in title insurance. And we'll talk about title insurance in a different chapter, but it basically ensures the ownership interest of the buyer. Okay, the agency disclosure is something we've already talked about, who works for who, particularly important if it's a dual agency. Is it near an airport? I sort of feel like that should be obvious if it's near an airport, but that's something you're supposed to disclose, particularly, if you can hear the noise frequently if you're, spending any time in a property. Potential flooding. Okay, broker's duty to inspect the property. So both the seller's agent and the buyer's agent have an obligation to inspect the property and write their own reports as to what they see as perhaps anything that might have an impact on the value of the property. Carbon monoxide detectors have to be installed as part of a sale. So when the buyer takes ownership of the house, there have to be new fire alarms and carbon monoxide alarms. Okay. Commercial property owners' guides to earthquake safety. So if you're buying and selling commercial property, there are certain disclosures that have to be made about whether the building has to be seismically retrofitted or under what circumstances it has to be seismically retrofitted. Has there been any death within 3 years? Okay. Is there a farm or ranch in proximity? Anyone know what's the point of that? First of all, I would think that would be kind of obvious, but anyone know why that needs to be disclosed, that you're within a certain proximity to ranches or farms? Any ideas why? Yeah, Paul.
Like animals and stuff like that.
Smell. Yeah, that's right. Okay. It's interesting. Jim Poita will talk about this when he comes on October 30th, but he'll talk about the importance of knowing your market. And this is something I did not know, but it's something that in general probably should be disclosed for people who are looking to buy in Morgan Hill. Does anyone know there's a weird smell issue in Morgan Hill? Does anyone know what I'm talking about and why it's there? There are a lot of, and I learned this from Jim Poita actually, there are a lot of mushroom farms in Morgan Hill. And so there's a lot of manure used as fertilizer. And so there can be manure smells in Morgan Hill because of all the mushroom farms. So that's something you may want to know about. If you are buying government-owned property, there has to be an inspection report prepared by the federal government. And that's kind of rare. Withholding and federal withholding and California withholding tax. So this is a disclosure actually made to the seller. And what it tells the seller is, okay, so let's say Paul just sold his house and he netted $1 million, meaning let's say he owned the house free and clear and he sold it to me for $1 million. Okay. He's not going to actually get $1 million check at the end of escrow because escrow is required to withhold 10% of that money for the IRS to basically guarantee payment of any taxes he may owe to the IRS as a result of making a profit on a sale. And the escrow company must also withhold 3 1/3% to pay state income taxes. So basically, Paul's going to get about 13 1/3% less money than he may have been intending to get, because these taxes are withheld in advance to guarantee payment. So that's just something he'll need to know. Flood disaster insurance requirements. This is increasingly becoming an issue, I think, particularly like in places like Florida. But in California, it's relevant if you're on a lake or river, or especially the ocean. Okay, like if there were tsunamis and things. If the property is located near any gas or hazardous liquid transportation lines, that's just something for the buyer to know. It could potentially be, a danger, I guess. Um, Groundwater Basin Comprehensive Adjudication Act. Okay. So this is relevant if you are buying agricultural land. And often what makes agricultural land valuable is if there's groundwater or not. And if there is no groundwater, that makes the land a lot less valuable because you'll have to bring in irrigation. And so basically, this is a disclosure having to do with the presence or non-presence of groundwater upon agricultural land. It's interesting. I read this article, I don't know, a few years ago that Harvard University's endowment, so they invest the money that Harvard University has, bought up a bunch of vineyards on the central coast of California, like near San Luis Obispo. And one of the reasons they bought them is that they feel like the water rights those vineyards have will be worth a lot of money in the long term. So they're not really buying vineyards; they're buying water rights when they invested in those properties. Okay, home energy rating system booklet. That's just more about like Energy Star and those things. Like, does the house have efficient equipment? Homeowner's Guide to Earthquake Safety. This is just kind of an advisory to you about things you can do to make your house more safe. I think this is that one's a little bit common knowledge, or you could easily look that up on your own. I'm not sure it needs to be a required disclosure. Okay, industrial use zone location, think sriracha. Does anyone know the company that makes the sriracha sauce got sued a few years ago? Does anyone know what I'm talking about? It had nothing to do with food poisoning or anything like that. Does anyone know? It was kind of a news story about 5-10 years ago. So they got sued by the property owners who own homes near the factory because of the smell of fermenting chilies during certain times of year. And so I guess it's quite offensive and quite, like noxious. And so if you're buying a home near industrial property, that has to be disclosed. Okay, Michael, you were going to say something?
I wanted to add to that because it's true. I remember that in the news out. It was on ABC 7,
Yeah.
where the homeowners basically said like, "Oh, living next to the factory, it's not great. It's irritating. The chilies are still, in the air, and it's just hard to breathe around the place, and it's not right."
Yeah. And so, then that becomes a whole issue of who was there first, and what was the zoning. And so I actually don't know how it all got resolved. I think the factory tried to take some steps to kind of keep the fumes in, but I could understand as a homeowner that might be, or a resident, that might be a legitimate problem, right? I don't think these people are just being whiny. So anyway, that's something to be aware of. Lead-based paint pamphlet. Okay, if you are buying a home that was built before 1978, when lead paint was banned in the state of California, that has to be disclosed. Now, I think most of us don't eat lead paint, okay? But who does eat lead paint? At least flakes of lead paint. Who puts stuff in their mouth all the time? Think about it. It's not a dog. Yeah, Devin?
Kids.
Yep, babies, especially toddlers. And so if a kid eats some flecks of lead-based paint, that can actually cause permanent brain damage. So that's something just to be disclosed. Okay, you have to disclose any kind of material facts. We've talked about that before that could affect the value of the property. Megan's Law disclosure. So that has to do with the presence of sex offenders in a neighborhood. Again, that is something you can look up on your own, actually, but it's just a disclosure basically saying, hey, did you know there's a database of sex offenders that live within a certain radius of this property? And you can look that up and see on your own. I can tell you this. I guarantee that 90% of you live near sex offenders, okay? The term sex offender is quite loosely defined. It doesn't always mean like hardcore pedophiles, but there are lots of sex offenders registered out there. If you actually did a search in your neighborhood, you'd probably find some. So I wouldn't also freak out necessarily. So for example, if an adult male has sex with an underage female, that's statutory rape. that's a sex offender offense. So if a 19-year-old has sex with a 16-year-old, that qualifies as a sex offense and a sex offender. So it's pretty liberally defined. Okay. Okay, Melrose bond assessments. Okay, so probably something you've never heard of before. And we'll talk a little bit more about this in the chapter on taxation. But okay, here's a trick question. Is Saratoga a rich city? Trick question. No, it is not. The city of Saratoga has very little money. The people who live in Saratoga, many of them are wealthy, but the city itself has very little revenue and has to operate quite leanly. And that's kind of a result of Proposition 13, which is something we'll also talk about later in the semester. But most cities in the state of California don't have much money. And so when a developer comes to town and wants to develop a new subdivision, the city basically says to the developer, we're not paying for your streets. We're not paying for your parks, your schools, your fire department. We're not paying for any of that because we don't have the money. If you want to develop in our community, you figure out a way to pay for it. So there's two ways of paying for it. The developer pays for all those improvements and then spreads the costs out to people who buy the new homes, or the developer puts a lien, and it's called a Melrose lien, and that's just the name of the legislators who came up with this concept. And that is a lien on property within a development to pay for, say, parks, fire service, etc. So if you bought a home, I'm just going to make this up. Let's say you bought a home in downtown Gilroy that was built in the 40s. You don't have these kind of liens on your property. But if you bought a home that was built in Gilroy, say in the 2000s, you probably have this lien on your property, meaning you have to pay more in taxes than someone who buys, say, a 1940s house. And so that's just to be disclosed. So what that means is if you bought one of those homes, you would pay the purchase price, you would pay your property taxes, and in addition to your property taxes, you're going to pay some sort of lien amount to pay for specific improvements. And so not a lot of people realize that. And so that has to be disclosed if there is an additional lien in addition to your regular property taxes. Okay. Meth lab cleanup order. Okay, that's no fun. But if your home is near within, I don't remember what the distance is, within so many feet of a property that was that was basically being used as a meth lab to cook crystal meth, that can have all sorts of environmental contamination, and that's something that has to be disclosed to potential home buyers. Okay. Military ordnance. If you're buying a home where there might be unexploded military ordnances, that's got to be, meaning basically old shells, artillery, bullets in the ground, that's got to be disclosed. Okay, where would that be relevant? Fort Ord. So if you know Fort Ord, it's near Monterey. It's just north of Monterey. It was an old military base. It's now been developed for homes. Cal State Monterey Bay is there. It's a huge new development. And I'm sure if you bought a home in that community, there's a disclosure that there is a chance there might be some unexploded ordnances buried, deep in the soil. Just so you're aware that there's some risk of that. Right? Any questions so far? I know I'm going fast, but it's not the most exciting topic to talk about. Okay. Mining operations. If there are any mining operations near you, that could be relevant because number one, it could destabilize your property if the mine, is nearby your property line. Also, it could introduce environmental contamination. Okay. Mold. If there is a presence of mold in the property that's being sold, that has to be disclosed. The pest control inspection report, that has to be disclosed. It's basically the termite report to let buyers know about the condition of the property. Is there a transfer tax? So every county and city in California may charge a transfer tax, and that is basically just a tax on you transferring your property from one owner to the next. And so if there is a transfer tax, you have to be notified about it. And in general, there usually is a transfer tax. Most cities and counties charge a transfer tax. Okay, residential environmental hazards booklet. This is just a booklet on, be careful of radon or carbon monoxide, be careful of pesticides. It's pretty basic stuff. Seismic hazard zones, that's more information about, are you located in an area prone to liquefaction? Does anyone know what that is? What liquefaction is? No. You don't, liquefaction basically means the soil liquefies. You don't want that. So let me explain. So some of you maybe might remember the 1989 Loma Prieta earthquake in the Bay Area. And parts of San Francisco, people died in San Francisco, in parts of San Francisco that were built on fill. Does anyone know what I mean by built on fill? Anyone know what that means, to build on fill? So large parts of San Francisco 100 years ago didn't exist. It was just ocean and the bay. Yeah, Monica?
It's landfill.
Right. It's based. So a lot of San Francisco that we think of as San Francisco was not there before the 1906 earthquake. But after the 1906 earthquake, when about half of San Francisco was destroyed, a lot of the rubble was used to expand the shoreline of San Francisco. So if you're familiar with the South of Market area in San Francisco, most of that didn't exist 125 years ago. It was all built on kind of rubble. If you know the city of Foster City didn't exist over 100 years ago. That was all filled in bay. And land that is filled in shakes a lot more than land that is bedrock. And so that's something just to be aware of. Yeah, Devin?
No, I was going to say or contribute something. Yeah, my mom sort of lives somewhere similar to that in Redwood Shores over the old Marine World.
Yep. And is it filled as far as you know? I think it is.
Yeah, but it's awkward because every time like you said, with earthquakes, every time I go over there and it's garbage day, like the ground shakes profusely.
Okay.
I mean, don't get me wrong, it's a nice area, but
the
ground isn't all there, you know what I mean?
Yeah, no, and so it just may shake more in an earthquake than say bedrock. So like West Valley College is built on bedrock. It's not, it's that land has always been there. So it's just less prone to shaking. Michael.
If I remember correctly, isn't there like a tower that's actually like slowly leaning but stopping because of that fill? Is that correct?
Millennium Tower. So, right, this has been on like 60 Minutes. And I actually don't know if that particular area of San Francisco was built on fill, but basically, right, there's this tower that's probably 50 stories high. I think the minimum price for a condo unit is $1 million. And the HOA fees, I think, are at least $1,000 a month. You have to have a lot of money to buy in that building. So, Mike, do you know what the story is then, Michael? Yeah, because it's. What have you heard?
Well, from my own understanding, I've seen like videos of people talking about like, oh, this building, it's just slowly, waning because of the fact that the foundation, that the fill isn't really reinforcing the structure, or the Millennium Tower. And even though it's slowly moving, sometimes it's really hard to explain, but basically it's right now like stopping, but it's still ongoing.
So it's not like the Leaning Tower of Pisa where you can see it. It's not that drastic. And I think if you're in the building, it's not like you feel like this all the time. But on 60 Minutes, they did an episode about it, and they showed a guy in his, like 30th floor unit, which has beautiful views. He took a marble and put it on the floor, and the marble moved. That was that much of an angle that the marble could roll. So the homeowners are saying the developer screwed up and did not properly install the foundation. The developers are saying that it's construction by other projects in South of Market that's destabilizing. Who knows? This is a massive, massive lawsuit. But if you bought a home in that building, no one's probably going to want to buy it from you, at least for what you paid for it, because there is just this unknown risk as to what's going to happen with that building. And yeah, you can sue the developer, but if the developer goes bankrupt, who's paying for the repairs? You are. And so this may mean huge HOA fee jumps. So yeah, that thing has gotten a lot of press all over the country because it's just kind of such a nightmare situation. Okay, smoke alarms. Okay, by law, smoke alarms are required outside each sleeping area. And if it's a new home, the smoke alarms have to be hardwired, meaning not dependent on batteries. And that is something the real estate agent has to follow. Okay. And you have to give a written statement to potential buyers that the house's smoke alarms are in compliance with the law. So that is the seller's responsibility, okay, not the buyer's. Special flood hazard area. So there are certain areas that the Federal Emergency Management Agency designates as especially prone to floods. And if you live in one of these places, you are probably going to have to get flood insurance because most homeowners insurance does not cover floods. That can be a very unpleasant surprise. Now, you may think, well, that's not really relevant to us. That's more like Florida and New Orleans. But people may remember in 2017, there was we had a lot of rain, and I think it was the Anderson Reservoir down south somewhere that overflowed, and it flooded Coyote Creek. And Coyote Creek goes right through San Jose, including near San Jose State. I have 3 very good friends whose homes were flooded up 2 stories because of that reservoir overflow. And so that became a huge nightmare for them, as you can imagine. And so there was a big lawsuit against the water district. But anyway, it was a big mess, and it was pretty gross. But these are just things to be aware of. Supplemental property tax. Oh, sorry, state responsibility. This is basically only applies in areas where there isn't like a local city government or a local county government. So if you were like sort of in rural way Northern California where there really isn't any local government or local fire company, that means you're going to be dependent upon state fire. So it's just for you to be aware of that there's less services because you're in such a remote area. Supplemental property tax notice. Speaking from experience, when you buy a home and the county is notified that the ownership has changed, a supplemental property tax bill will be sent to the new owner to account for the fact that the property tax basis for the house has changed from the sale of the house from one person to the next. You better pay that bill, okay? Because if you don't, you're going to get a big fat fine. And so that's something new homeowners may not be aware of. Subdivided lands law, something we'll talk about in a different chapter, but this only applies if you're buying a home in a brand new development. Subdivision Map Act, not really something you need to worry about. Developers need to worry about it, but not your average homeowner. The TDS, the Transfer Disclosure Statement, and then the Very High Fire Hazard Severity Zone is basically, are you buying a home in an area where there are special rules you have to follow? For example, you have to clear brush from around your house, you know, that kind of thing, okay? Now, interestingly, does anyone, so the market for people buying vacation homes or second homes in the mountains, say in the Santa Cruz Mountains or up in the Sierras or other communities, or like Nevada City, that area, Gold Country, that area, the market has really been hurt by a recent change due to all the fires. So when you buy a home, obviously you buy the home, you got to pay your property taxes. What else do you have to pay for when you buy a new home? What else do you have to pay for? And it's expensive. Anybody? What else? I know some of you own your homes. What do you have to pay for? Yeah, Monica?
Property insurance, fire.
Property insurance.
Yeah.
Okay. What's going on in places like Nevada City or the Santa Cruz Mountains or other rural areas, especially those rural areas prone to wildfires? What's going on up there? Anyone know what I'm talking about in terms of the insurance situation?
The fire that happened just in LA area, Pasalatis, that.
What's going on is most private insurers will no longer insure property of them. So that's huge. If you don't have insurance, that means if your property is burned down in a fire, you get nothing. And so, this is something that's really affecting the calculation whether you want to buy a second home or not. So we have friends who bought a second home at the Nevada City. They could not get insurance. And the only option is they have to get fire insurance through the state of California. That costs $5,000 or $6,000 a year, and it's fire only, nothing else. So you still need to get property insurance for everything else. And you need to spend $5,000 a year for fire insurance. So that makes the property expenses for insurance much, much, much higher than say around here. And so that's a real negative thing. The fact that you have to buy special fire insurance. Whereas like in San Jose, you don't have to buy special fire insurance. Okay, Michael.
Another thing to add to that is insurance, property insurance is usually something that banks usually want in order to, as part of the loan. And for new homeowners, this can be a big problem because it's like, okay, I'm going in a place that's like a fire risk, there might be an earthquake risk, and they want insurance, but if the insurance says, oh, we can't provide that, then it might be a big struggle, especially,
Totally. Or the insurance is outrageously expensive. So I don't know about you all, but my insurance, and I haven't had any claims ever, has gone up almost 40% in 2 years, my homeowner's insurance. And I basically called my broker, who I've worked with for a long time, and he basically said, don't even start. You're lucky to have insurance to begin with. The market, it is really tough market for insurance now. And I live in central San Jose. It's not like I'm up in the mountains or something like that. So it's a tough market for insurance. It's even worse if you're in areas that are prone to wildfires. There, you're probably not going to get insurance. So or you're going to get insurance that's very expensive, and that makes home ownership more unaffordable in those communities. For my friends, it's their vacation home. They can deal with it. But if you lived in that community as your primary residence, it makes owning a home much more expensive because the insurance is so expensive now. All right. Okay. Water compliance. Here's another disclosure. Okay. So this is basically a disclosure that tells you under California law, if you have a home built before 1994, you have to bring it up to code if you do any modifications to install water conserving appliances. Okay. And then under state law, you're supposed to actually remove any kind of device that doesn't conserve water. I don't think that's really enforced. Water heater bracing statement. That is something that the seller has to ensure that the water heater is braced so that if there's an earthquake, it won't tip over and start a fire. Right? And then if there are any window security bars on the windows, there has to be a way for them to be released from the inside in case of fire. And that is something the seller has to disclose to the buyer. Okay, that's a hell of a lot, right? Some of it's legit. Some of it I think is important for people to know. But a lot of it I think is kind of common sense, or it's information that the average buyer should be able to figure out on their own. And so I just feel like, as I said before, there's just so many disclosures that they kind of lose all meaning. And I feel like there should be more of a focus on the disclosures that are really important, as opposed to like, you live in California, California has earthquakes, that kind of stuff. Okay. Now, a couple of last things. Statewide buyer and seller advisory. It's one more form that is basically just a laundry list of all the things that could go wrong with a home. Okay. All right. It's unlikely most of those things will happen, but it's just to make buyers aware of that owning a home has some risk. And I do think it's good of reminding the buyer to do their homework. A lot of buyers don't do their homework before buying a home, and you should absolutely do your homework by doing that. Also, this is an advisory given to buyers that protects the sellers, because the sellers can say, look, I advise you to do your homework. I advised you to look at the foundation. Don't blame me for yourself not doing your own. Okay. Whew. Okay, we're done. That was chapter 5. Okay. By far, that'll be the quickest chapter we do the whole semester. Now, on the midterm, so there's 5 chapters on the midterm, and there's 50 questions. Sorry, there's 5 chapters covered by the midterm, and there's 50 questions on the test, which basically means there'll be about 10 questions per chapter. Okay. And so I expect you to basically spend about the same amount of time studying each chapter. Okay, roughly. I would say for this chapter, I don't think you need to memorize the details of each advisory, but I do think you should have a basic familiarity with what each one is about. The good news is the title of each disclosure, I think, kind of explains what it's about. Okay, so I'm not going to get super nitpicky with you on it at all. Okay, now when you take the state license exam, they might get nitpicky, but I don't see the point in getting nitpicky with you about it. Okay, but just realize about 10 questions on the midterm will come from chapter 5. Okay, all right. So now, okay, so that was a painful chapter to get through. Now let's get to a chapter that I think is more interesting, which is contract law. Okay. Okay, now you may be thinking, why are we covering contracts? This isn't a business law class, okay? There's 2 reasons why we're covering contract law. Number 1, because the DRE requires us to, okay? But number 2, I actually think you should know about basic contract law because real estate transactions live and die based upon the contracts. And so I think it's good to understand just sort of the basics. Now, if you've ever taken business law, a lot of this should be reviewed. It shouldn't be hard, okay? But I'm not expecting you to have exposure to contract law before, okay? So contracts are beautiful things because they make your life predictable. You can plan for the future, okay? As any business owner will tell you, the worst thing about owning a business is uncertainty, and contracts give you a lot of certainty, all right? So, okay, so I'll tell you a story that kind of shows the importance of contracts. Okay, so let's say I sign a contract to buy Michael's house today for $1 million. Okay, what's the standard down payment typically? Or yeah, what's the standard? I shouldn't say down payment, standard deposit. Typically, when you buy a home, anybody know? If you've bought a home, you did this. You want to know what this? Yeah, Paul.
Is it 20% of the?
Okay, so I kind of misled you guys. The down payment is 20%, meaning what you have to cough up of your own money. I meant, and that's what you pay at the end of escrow. I meant the day I signed the contract with Michael, what do I have to write a check for? How much? Anyone know? No one remembers this from when they bought a home? It's 3%. Okay, so that's $30,000. Why would I give? Okay, so I'm going to give Michael $30,000. He's going to give me a piece of paper. Okay, and that piece of paper is called a contract. Why am I going to be okay with that? Because let me ask you this. How long before I get the keys in the house? Typically, how long before I get the house? So he and I signed the contract today. When am I going to get the house roughly? Yeah, Devin?
45 days.
It's a little on the long side. I'd say 30 to 45 days. Okay, let's say a month. I mean, it used to be typically a month, but now sometimes with financing, it gets drawn out a little bit. Okay, but let's say a month. Okay, why on earth would I give him $30,000 today and all I get is a contract? Why would I do that? I mean, that seems crazy. I understand why Michael does it because Michael just got 30 grand. But why does it make sense for me to do that? It's a huge risk I'm taking. But is it? I mean, this is what most people do in real estate transactions. Why is it not as risky as it seems? I mean, there is a danger Michael might take my money and run. But what makes me think he probably won't? And it has nothing to do with Michael's honesty or whatever. Yeah, Michael?
Could it be because it's in writing?
And what do I know if Michael tries to run away with my money? What can I do to punish Michael? Yeah, Devin?
Sue him. It's contractual.
Yeah, for breaching the contract. Okay? The contract gives me the right to sue him, and he knows there will be consequences for him if he tries to take my money and run. And so the reason why I'm willing to do that is give him the money is because I have a contract guaranteeing his performance. Now, is it 100% certain that everything will go through? No, but it's pretty likely. Okay, so I will tell you a story that I had a former student who took my class who was going to get his broker's license. He was a guy in his maybe early 40s, I would guess. he was a Russian software engineer, and he told me a story about when he bought his first apartment in Russia in the early 90s. And this is when Russia was transitioning from communism to capitalism, and things were kind of chaotic, and there wasn't much of a legal system. So he told me that a contract was useless in Russia at the time because there was no legal system to back it up. Okay. So he said, this is how you would buy an apartment at the time. So he reached an agreement to buy an apartment for, let's say, $30,000 in Russian money. So he said, this is the way you would do it. You would reach an agreement with the seller and you would shake hands and you'd agreed upon the price. The next day, you meet the seller in a car with darkened windows and surrounded by men with guns. And you bring the purchase price in cash in a briefcase. That's why you hire men with guns. And the seller brought a cash counting machine to count all of Igor's money to verify it was all there. And he said, once he verified that I had brought all the cash, he gave Igor the keys. And Igor said, you had to move in immediately or else squatters would move in and it becomes a nightmare. Okay. Now, could Michael and I do that kind of transaction if we wanted to? Meaning we shake hands, I meet him the next day with $1 million in cash in a briefcase, we hire guys with guns, all of that. Could we do it that way if we wanted to? Sure, we could. I mean, if we both agree to it. But is that an efficient way of doing business? No. It's much better to have a contract that you know will guarantee performance under most circumstances. Okay. And things are different now in Russia, but at the time, that was the way you would do transactions. And so contracts allow you to plan for the future. There's a postscript to that story. I would say at least 10 years later, I had a woman who took this class, and she was like probably late 40s, early 50s, and she was Russian. And she came to talk to me once. This was a face-to-face class during office hours. And she wanted to go over the test. And so we talked about some various things. And then at the end, she said, oh, by the way, I'm Igor's ex-wife. I'm like, what? She goes, you know that story you told about the apartment in Russia? I'm Igor's ex-wife. Oh, were you there? She goes, oh, yeah, I remember that transaction. It's like, well, did I get it right? Did I say it right? She goes, yeah, that's what happened. So I was like, this was halfway through the semester and she had never identified herself. I was like, I can't believe you waited this long to tell me that you were related to Igor, but at least I know that I'm getting the story right. So that was just a weird coincidence. So anyway, that's not the way we do things here. We have contracts, which are a much more efficient way of doing business. Now, a contract doesn't guarantee everything's going to work, but it's going to make it most likely it's going to work. Okay. Now, also in reality, if I was buying Michael's home, I do have to write a check for $30,000. That's for sure. Do I give him the check? That is a little risky because Michael could go cash it and flee the country, right? Who gets the 3%? Anyone know? And we'll talk about this process later in the semester, but you actually don't give the 3% to the seller. Who do you give it to? And you don't give it to the agents either. Yeah, Monica?
The escrow company.
Exactly. You give it to the escrow company and they will keep it safe. So I feel comfortable doing that because I know we have a contract and the escrow company will follow whatever the contract says. Okay. All right. So what is a contract? A contract is an agreement to do or not do something in the future in return for something else. Okay. So there can be all sorts of forms of contracts. It just depends on what the parties want to do, as long as both sides are giving something up. Okay. But contracts do not need to be equal. Okay. As long as both parties entering into a contract are mentally competent, whatever they agree, that's fine with the court. Courts don't question the fairness of a contract. What is the problem with questioning the fairness of a contract? So courts don't question whether this is fair. Why? Think about it from a practicality point of view. Any ideas? What would be difficult about questioning the fairness of a contract? Anybody? Can you define fair? Yeah, Monica?
It doesn't want to like take side, either seller or buyer.
Also, what is fair, right? What is fair to you might not be fair to me, right? Fair often depends upon the context, right? Are you more willing to pay more for, say, a drink at a resort than you are at Safeway, even though it's the same exact, drink? Yeah, because the context's different. Does that mean at the resort it's unfair, but at Safeway it's fair? Not necessarily. It's up to the parties. And again, as long as both parties are competent, you are free to make as stupid a deal as you want. Yeah, Devin?
Well, that's what I was gonna say. Isn't a signature regardless?
No, not in general, yes, but in reality, there are always exceptions to the rule, meaning you can sometimes get out of a contract under certain circumstances, but it's hard. Let's just put it that way. I just don't want to say always a signature is a signature. That's not always true. Right? Now, okay, so just to give you some context about the complexity of contract law, if you're in law school, you spend a year on contract law. So I took a year of contract law. If you take business law, which is a required course for business majors, that's a month on contracts. We're going to spend one night on contracts. So we are greatly simplifying. Okay, but these are the basic rules that apply. Oh, I should say this. These are the basic rules that apply to any contract, not just real estate contracts. Okay, these apply to any contract, not just real estate contracts. Okay, so first of all, let's just talk a little bit about what kind of forms contracts come in. Is an oral contract valid? Also a trick question. And remember, participation's, a chunk of your grade. It's a good way to, if you know you're going to be weak on tests, participation is a great way to offset your grade. Yeah, Monica?
No,
Well, not exactly. Devin, what were you going to say?
A bilateral contract.
Well, that's different. That's a different way of classifying it. I don't want to go there yet, okay? Just, is an oral contract valid? The answer is usually yes. If what? An oral contract is valid if, what is yeah, Michael?
An oral contract is valid if it's in writing. If
No,
it's
no. There's nothing in writing, but you're getting close. An oral contract, is it valid? It is if what? You can prove it. Okay, you can prove. So Michael and I have an oral contract. Is that actually valid? Well, only if we can convince a jury that it's valid. Okay. Yeah, Kenny?
So can we let's say we have like a oral contract and we have a record the recorder. Does it convince judge or court?
Okay, well, if you and I have an oral contract and we agree that we have an oral contract, we don't need to go to court because we'll just perform like we said we were going to perform. It becomes an issue if after we have an oral contract, I claim we don't. You could take me to court and try to show through evidence or witnesses or whatever that we do, and I would try to show through evidence and witnesses whatever that we don't.
Right.
Oral contracts are not a good idea,
Okay.
okay? Because they're hard to prove. But they are not automatically invalid, okay? But here's the trick. I said this was a trick question. In real estate, they are invalid. So California law is quite clear. All real estate agreements and transactions have to be in writing. And if they're not in writing, no good. It doesn't matter. You can even prove that they existed orally. It doesn't matter, okay? So I think I mentioned a while back, there was this commercial real estate broker who worked with a client, helped him find a property. The client owed him $100,000 commission, and this is 45 years ago. Because the listing agreement was never in writing, even though the client admitted that they had an agreement, the court refused to enforce it because nothing was in writing. So remember this, oral contracts are valid if you can prove them, but in real estate, they are not valid in real estate transactions. So just keep that in mind. Now, Michael said something that sounded a little contradictory, but it reminded me of something. He said, an oral contract is valid if it's written down. That's actually true. So think about it this way. Michael and I agree via, like, let's say he sticks around after class and we talk and I say, hey, do you want to buy my car for 10,000? He's like, yeah, I do. And so like, cool. We'll meet on Monday and I'll give you the car and the title and you give me the money. He's like, yeah. As soon as we sign off, I then email or message him or whatever saying, hey, Michael, this is just to confirm, we had an agreement that you're going to buy my car for $10,000 payable in cash on Monday at noon. Can you please confirm? And he writes back saying, yes, Lance, that's all correct. Boom, we have a contract. Now we have solid proof. So especially in the era of email and texting where it's so easy to, write someone, whenever you have an oral contract, because you don't carry around contract forms with you all the time. Whenever you have a handshake deal, get it in writing as soon as possible and get the other party to confirm. And one reason why oral contracts are also problematic isn't necessarily because one person is dishonest, one person's honest. Two honest people may have two different recollections as to what they agreed. And so if I put in writing right after Michael and I get off class saying, hey, Michael, you're going to buy this 2010 car for $10,000. If that's not the price he thought it was, he could write me back saying, no, Lance, I agreed to pay you $9,000, not $10,000. And that way we can clear up misunderstandings instead of arguing on Monday, like you told me 10,000. No, I told you 9,000. No, it goes back and forth. Get it in writing. I mean, a text is good enough. Okay. Email might be better because it's slightly more formal, but anything in writing is better than nothing in writing. But just realize that oral contracts can be valid, but you want to avoid them. Monica.
I have a question. So right now the buyer have to pay the buyer agent fee. So now the agents are asking the buyer to sign the contract. How long
Yes.
does that contract last?
I think it depends on whatever the parties negotiate, but probably 3 months.
Okay.
Probably 3
Otherwise,
months.
they have to call the agents and say, hey, I'm not hiring you anymore. Something
Well,
like
there
that.
will always be a time limit in there. And then after the time limit, the agent's going to want to say, hey, do you still want to work with me? Or if the agent's tired of working with you, they may say, you know what, you're free to go work with somebody else. Okay, an express contract is one where it's clear the parties have agreed to something, preferably in writing. Like, I agree to sell Monica a car for $10,000. Okay, that's express, it's clear. Okay. An implied contract is something you want to avoid. An implied contract is where it's implied that we have an agreement, but it's not really written down anywhere or completely stated. And the problem with that is that can lead to misunderstandings. So a classic sort of business law textbook example of an implied contract is this. Every day I go into Monica's grocery store and I buy a candy bar at lunch for $1. Okay. I do this every day on my lunch hour. She knows me. One day I go in and I'm really short on time and she has a huge line of customers. I don't really have time to wait. So I get eye contact with Monica and I take the candy bar and I go like that with it to her. And she goes, okay, that's an implied contract. What is the contract? So we didn't say a word. We just used, eye contact and me shaking things and whatever. What is the contract we just agreed to? Any ideas? How would you interpret that behavior? Yeah, Michael?
I'm going to take this candy bar and I'm coming back to pay later.
Or I'm going to pay you tomorrow, right?
Mm-hmm.
And now, would Monica do that with a complete stranger? No. It only works because she knows me, okay? And if she had said no like that, that would tell me she's not okay with me taking the candy bar. Yeah, Carmen?
Hi. But how you in that case, how you going to deal with the money? So how you gonna set up, a payment? How you gonna the buyer gonna pay at the real estate agent?
Well, that's
When
not, you would never do this in real estate. This is just an example of an implied contract. In real estate, unless it's in writing, it doesn't matter. It's as if it doesn't exist. If it's not in writing, it's not real. Think of it that way.
Okay.
Right?
Okay. Thank you.
Yeah, so in real estate, you never want to have an implied contract. Okay. All right. Devin mentioned bilateral contract. A contract is either bilateral or unilateral. A bilateral contract is where the parties each promise to do something. Okay. So an example would be this. I promise to sell my car to Carmen on Monday, and she promises to pay me on Monday. When we sign the contract today, nothing's happened. It's all off in the future, but we're both promising to do something in the future. That is a bilateral contract. A unilateral contract would be one where we say, I will pay you if you do this for me, but you don't have to do it for me. So it would be like this. I say, Michael, if you mow my lawn by Monday at noon, I will pay you $50. Okay. How does Michael accept that offer that I just made? How does he accept my offer? Don't overthink this, people. It's easy. So I say, Michael, if you mow my lawn by Monday at noon, I'll pay you $50. No ideas how he would accept that. Just think, put yourself in his shoes. Yeah, Paul?
By mowing the lawn?
Exactly. And if my lawn has not been mowed by Monday at noon, should I assume Michael rejected my offer? Yes. Okay.
Yes.
So bilateral, by meaning to, means a promise for a promise. I will sell my car to Paul on Friday or on Monday. Paul agrees to pay me on Monday. We are each promising today to do something on Monday. A unilateral, uni meaning one, means I make a promise, but the way Michael accepts my promise is by performing, is by actually doing the job. Okay. A void contract means one that is dead. Okay. Void means dead, no good. Okay. A voidable contract is one that might be dead. Okay. But might not be. Okay. If I sell a car to a 17-year-old, that's to a minor. Okay. If I sell a car to a 17-year-old, can I cancel the contract because I sold it to a 17-year-old? Can I cancel the contract? The answer is no. Why? Why can't I cancel it? Why can't I cancel it? Am I an adult? Do I know better in the eyes of the law? Yeah. Once you enter into a contract, you can't just cancel it. But why should a 17-year-old have the ability to cancel it? Because a 17-year-old can cancel it. So the adult can't, the 17-year-old can. Why? Just think from a fairness point of view. Buddy? Just think of. Yeah, Monica?
17 is a kid.
And so in the eyes of the law, they don't know what they're doing. Okay? It's like if I sold the car to someone who had dementia or was developmentally disabled or was drunk, they don't really know what they're doing. And so if I sold a car to a 17-year-old, the contract is voidable, meaning it is cancelable. It might be canceled, it might not be canceled. What about this? I sold a car to Monica when she's super drunk. She doesn't even remember buying the car. The next morning, she sobers up and she's like, oh, I bought a car. Can she keep the car if she wants to? Yes, once she sobers up. But can she also cancel the contract if she wants, if she can show that she was drunk? Yes. So voidable just means might be canceled, might not be canceled. Okay. Unenforceable means it was a valid contract, but something happens and now it's no longer valid. Okay. So for example, Michael and I had a valid contract that I'm going to sell him my car on Monday. Okay. It's a valid contract. We're both adults. Okay. Sunday morning, my car is destroyed in a fire. Okay. I can no longer sell him the car. The contract has become unenforceable because there is no car left. It's not like I did anything, shady or dishonest. It's just, I can't perform now. Okay. So like if I'm a real estate agent, you hire me to sell your house. We have a contract that I get the right to sell your house. But if your house burns down, that contract is unenforceable because there's no house to sell. Okay. Okay. An executed contract means one that is finished. An executory contract means one that is not finished. If I sign a contract today to buy Michael's house, that contract is executory because it's not finished. But when escrow closes, I've given him the money, he's given me the keys, that's executed, it's done. Okay. And then one last thing is, what are statutes of limitation? What are statutes of limitation? They exist for contracts, but they exist for all legal actions. Anybody? No one ever heard of a statute of limitations? You guys are a really quiet class. It's a time limit. Yeah, Devin, please.
Oh, no, I was going to say the same thing. It's enforceable time until to bring legal action, until the time to bring legal action has expired.
That's right. Okay, so I'll give you an example, okay? Most contracts have to be enforced within, let's say, 3 to 5 years. That's the general rule, okay? Devin loans me $5,000, and I'm supposed to pay him back December 1, 2025, okay? I don't pay him back. We have a valid contract. He can sue me, and he'll win. Devin's a busy guy, he kind of forgets about it, and then he's like, oh yeah, I need to sue Lance. So he sues me in December of 2032. What's my defense? My best defense. He sues me in 2032 over the loan from 2035. I'm sorry, from 2025. You don't have to think hard about this, people. It's what we've just been talking about. Yeah, Devin?
Time has lapsed.
You waited too long. The statute of limitations has run. Okay. Even though it's true, I still owe you the money, it's too late. So the contract became unenforceable because you waited too long. So every legal claim you have has a time limit. And if you don't meet the time limit, it's too late. Now that may seem harsh, but on the other hand, a court's probably going to say to Devin, why'd you wait 7 years? Right? Like all the evidence is gone, memories may have faded. It's just too late. 5 years is, you have quite a bit of time to sue me, right? And you blew it. And so a contract can become unenforceable if the statute of limitations, SOL, that's the abbreviation, if you've taken too long. And every legal action you want to take has a time limit on it. Okay. So you guys may remember that, like back in the teens, especially, there were all these child sex abuse cases against Catholic priests. All right. A lot of those lawsuits were thrown out based upon statute of limitations. What do I mean? Why were a lot of those lawsuits alleging, child abuse thrown out? It's not because the courts were saying these people who said they were molested are lying. That's not the reason at all. Yeah, Monica?
It happened too long ago. So.
Exactly. And I mean, that seems harsh, but imagine if someone accused you of molesting them 30 years ago. How would you defend yourself against that? Right? It's almost impossible. Yeah, Devin?
Well, I mean, with that much amount of time, I'm sure evidence has been destroyed, like things are missing, people may have forgotten, there's just a lot to account for. It's
just too late, right? The laws, I think, have changed so that, number one, the statute of limitations, I think now doesn't run until the person who was allegedly molested, it becomes an adult, right? Like you can't expect a 5-year-old to know their legal rights kind of thing. The laws have changed since then, but at the time, you only had so many years to file a molestation case. And in most of those instances, it was just too late. So, okay. So if your claim is prohibited by the statute of limitations, it doesn't mean your claim is bad. It just means you waited too late to assert what might have been a good claim. Okay. All right. We'll next talk about the elements of a contract, but let's take a break. We've gone through a lot of stuff tonight already. So let's take a break and let's meet back at 5 after 8. Okay. Yeah, Michael?
I got a quick question earlier about the disclosure.
Let's wait until after the break. Just, I like everyone to hear questions unless it was something personal, but if you're okay with that.
Okay, that's fine.
Okay, all right, great.
Oh, I just wanna, I, I came in late. So if you do the roster,
I'm not taking roll anymore. You're
Okay.
good.
Mm, thank you.
Hello again. Um, okay. Let's see. All right. So, Michael, you had a question that I put off. What was your question?
My question is, I know that there are some buildings in California that are made in the 80s or 90s that have asbestos, which is a
Yeah.
chemical that's very common. And the question is like, where would you address that as a disclosure?
So, that's interesting that I'm not aware of any like mandatory disclosure, although certainly if you knew there was a presence of asbestos, that's something that could have a material impact on the value of a property, so it should be disclosed. And it's actually, I think it's much more common in older buildings. So asbestos is a naturally occurring substance that is great at stopping fires. And so it was often used as insulation because it would prevent the spread of fires from one room to the next. The problem is asbestos, if it becomes what's called friable, which means it kind of breaks up into particulate matter. If you inhale it in your lungs, it can cause cancer. So it's nasty stuff and you don't want it. But on the other hand, because I actually owned a house where we think some of the linoleum had asbestos in it, so when we had it removed, um, if you leave it alone, it's not going to bother you. So, like a lot of homes that were built in the say the 50s or the 60s may have asbestos, but it's not a problem unless you're going to do demolition work or something like that or remodeling. So, but I'm not aware of any specific form you would fill out. But obviously, you would want to disclose that if you knew it and you were selling a home, saying that, hey, there may be asbestos. And if someone asks you, is there asbestos in this home? If you don't know the answer, you just tell them the truth, which is, I don't know. You shouldn't tell them, no, there's no asbestos. You should tell them, I don't know, which is the truth. Okay, there's nothing, if you really don't know, there's nothing wrong with saying, I don't know. And then that puts the buyer on notice. They may have to do some additional homework, maybe. Okay. Great question. Any other questions? Okay. So one thing you should know is a contract isn't a contract unless it has 4 elements. Okay. Capacity, agreement, legality, and consideration. Okay. So all 4 elements have to be there in order for it to be a binding contract. Okay. So what does capacity mean? It's not fair to enforce a contract against someone who doesn't have the mental ability to understand what it means. So, for example, it would not be fair to enforce a contract against a 5-year-old, right? 5-year-olds don't understand what contracts mean, okay? So that would be minors. It's not fair to enforce a contract against someone who's intoxicated, okay? Because obviously you don't do smart things when you're intoxicated. Now, what is the problem if I sold Michael something and the next day he says, oh, I was intoxicated, I want to cancel the contract? What is the problem with claiming that you were intoxicated when you signed a contract? Or what's the challenge of that? Anyone? Just think it through. So Michael calls me and says, oh, I was intoxicated last night when I signed the contract. Could he just be faking it? He just has second thoughts, right? Like, yeah, Monica.
So you have to prove it you're drunk.
Prove that you were drunk last night. Good luck with that. It's very hard to prove. Okay. If you are mentally incompetent, you're developmentally disabled, you have dementia, Alzheimer's, something like that, you don't really understand what you're doing. This is particularly something you should be concerned with if you have elderly family members who are still making legal decisions, because your elderly family member could enter into a contract, and they may not really know what they're doing. And so something you want to always have a conversation with about your elderly relatives is getting power of attorney for them, so that they appoint you to kind of look out for their affairs. That's something you should always think about. Now, not all elderly people need that, but it's something you should be aware of. And I've had a number of like neighbors where They got dementia, they were super with it, super educated, and then their 70s dementia came on, and it came on fast. And so they became incompetent. I had an aunt who, when she was 92, she was still driving on the freeway, totally with it. I would talk to her and I'd play with it. And then she had a stroke and a heart attack in one day. And after that, mentally, she was kind of there, but not really. And it became a problem for her two kids in terms of dealing with the real estate that my aunt owned, because they had never really, had the conversation about what happens if she becomes mentally incompetent. So it just became challenging. So something you might want to think about. Now, this is a story an appraiser told me like 20 years ago, but it's still a great story for purposes of this class. So as far as I know, this is a true story, and there wasn't a news article I read about it. There was a woman who lived in Los Gatos who had owned land since the 60s. And she was like in her late 70s, I think. And she had owned this land for a long time. And in the 2000s, she decided to sell it. And so when she bought the land in the 60s, it was worth nothing, or, like $30,000 or something. And she decided to hire a longtime friend of hers who was a real estate agent in Chico. And she asked her friend, what do you think I should sell this land for? And the woman told her $2 million. Now, the old lady was thrilled because that's basically $2 million cash, since she had paid nothing for it. So she listed the property for sale for $2 million, and a developer saw the ad and decided to buy it right there. He basically got a cashier's check. He didn't negotiate. He just like, I'll pay whatever you're asking. Okay. So the old lady's happy because she just made $2 million. The developer's happy because he just bought land for $2 million that's worth $6 million. Okay. So he got a steal on the land. So her kids found out about this and sued, saying the contract is no good because mom was incompetent. Okay. Was she incompetent? Because if she was incompetent, the contract's no good. So was she incompetent? That's the question. Right? What is the problem the kids are going to run into with that argument, saying mom was incompetent? Yeah, Devin.
Mutual consent.
There was mutual consent. No one was forced into it. But if like grandma has dementia or Alzheimer's, you can't really say her consent was valid, right? So it's not just that there was consent, but just because. So was she incompetent, meaning mentally deficient? Yeah, Monica.
So the kids have to prove the mom is incompetent.
And that's not easy without a medical diagnosis, that kind of thing. Here's what I think. The mom was something that starts with an I, but not incompetent. She was ignorant of what her land was worth. That doesn't mean she's incompetent. And the court refused to cancel the contract. So the contract went through. Okay. So think about this. Was this woman incompetent? No, she knew enough to hire a real estate agent. If she had just put an ad, online, hey, I'm selling my land, I think I'll ask $2 million. That maybe shows maybe something's a little bit wrong with her. But she actually did what you're supposed to do. She hired a real estate agent. Okay. Now, did the old lady really have no idea what her land is worth? Yeah. But does that mean she's incompetent? No. Okay, Monica.
So she hired that real estate agent. The real estate agent's at $2 million. So the real estate agent is incompetent.
Yeah. I mean, this proves the point. You should never practice real estate in a community you're not familiar with. You think the Los Gatos market is a little different than the Chico market? I mean, this real estate agent made a huge mistake. So unfortunately for the kids, they're not going to see any more money out of the property, okay? Because mom was not incompetent. What they should do is sue the real estate agent for basically incompetence, okay? But just because you're ignorant doesn't mean you're incompetent. So I had a guy take I used to teach a lot more variety in real estate classes. I don't teach as much as I used to, but I had this one guy who was a psychiatrist who took all the real estate classes. And I kind of asked him, like, you're a psychiatrist. Why are you taking these classes? And he basically told me, I kind of got to know him. He was a little bored with psychiatry. And he wanted to develop a practice where basically he would get involved in real estate disputes, and he would hire himself out as someone to evaluate whether someone who's allegedly incompetent, were they in fact incompetent or not. So you would hire him to either prove that your relative was incompetent or not incompetent. And so that's how he wanted to get into the real estate field. He did not want to become a licensed real estate agent, but he wanted to learn more about real estate just so he could kind of understand the complexity. So I don't know what he ever ended up doing with it, but I always thought that was kind of an interesting angle he had. Okay, so yeah, June.
In the case in the case you
Sorry, I
just
can't hear you.
hello?
Yeah,
Huh?
I can barely hear you. It sounds like you're really far away.
Then that's okay.
Okay, that's much better, whatever you just did.
Oh, I was asking the case you just gave. If the children sued a real estate agent, I'm just wondering, can the real estate agent afford to any punishment because the land already sold, right? The difference like a $4 million.
Yeah.
And then is it useful to sue the agent, assuming the agent is not able to, afford a $4 million?
Well, hopefully the brokerage is. The brokerage will have to pay for this, right? So if the brokerage is any good, will have required the agent to carry something called errors and omissions assurance, and that covers things like this. Okay?
Gotcha.
But you raise a good point, right? If let's say the woman who gave the bad advice was a broker herself and worked for herself, and she didn't have insurance, you may be out of luck. You may not be able to get anything. So that's a real problem. Was there another question out there? Okay. Okay. Now, Lucy versus Zamer is not in your textbook, but it's kind of a classic contract law case that has to do with competency. So it's from the 1940s in Virginia. So Lucy is a man. It's Mr. Lucy. Mr. Lucy wants to buy Zamer's land, some rural land. Zamer won't sell. And Lucy's tried over the years, but Zamer just won't sell. One day, Zamer was in a local bar. This is small town Virginia. And Lucy came into the bar, and Zamer kind of teased him, saying, "Hey, you still want to buy my land?" And Zamer said, "You wouldn't sell me the land even if I offered you $50,000. Okay. I don't remember the exact price. I'm just making that up. And Zamer said, "Oh, yeah?" So then, while drinking alcohol in a bar, they talked for 45 minutes. They wrote out the terms on a napkin, and Zamer's wife was there to also sign the napkin. So Mr. Zamer and Mrs. Zamer signed the napkin. Okay. A few days later, Lucy calls Zamer saying, "Okay, I've got the loan. I'm ready to proceed with this transaction." And Zamer says, "Oh, that was a joke. Okay. I was drunk." Okay. The problem with claiming that he was drunk is that, prove it. How do you prove that you were drunk? You could say, well, maybe he has bar receipts. Well, maybe he was buying drinks for his friends, right? It doesn't mean that he was drinking all that alcohol. You can't really claim that he was drunk, okay? Then he also claims, and we'll talk about this in a minute, a contract isn't a contract if it's a joke, meaning I assume you guys all know that if I'm saying, "Hey, Michael, you want to buy my car for 10,000, whatever," you guys know I'm joking, right? I don't want to do business with any of you, okay? So Zamer said it was a joke. If you were Lucy, why would you argue it wasn't a joke? And I gave you guys all the facts that are useful to make the argument why it wasn't a joke. What? Yeah, Kenny.
Because they're have a written letter on the napkin, and also have a witness or the wife.
If it's a joke, why'd you write it down? Now, they wrote it on a napkin, which is not ideal, but it's better than nothing, right? There was no texting back then, so it's about as good as they could do. If it's a joke, why'd your wife sign it? And if it's a joke, why'd you talk about it for 45 minutes? That's a long joke. And so the court said there's a contract. And so they forced Zamer to sell the land. So if Zamer was joking, he shouldn't have let it go on for so long. Now, is it a good idea to drink alcohol while negotiating real estate transactions? No, it's a terrible idea, but that's what happened in this situation. Okay, so I think it's understandable that you have to have capacity. It's just not fair, okay? Next thing you have to have is agreement between the parties. Both parties have to consent, okay? So think about this. All contracts are agreements. Not all agreements are contracts. Okay, I'll say that again. All contracts are agreements, but not all agreements are contracts. Okay? Kenny and I agree yesterday it was kind of hot. But then later I changed my mind. No, it wasn't that hot. Can I sue him because I now disagree with him? Or no. Okay? Devin and I agree that we're going to meet for lunch tomorrow at a certain restaurant at noon. We have an agreement. We texted it, so we have written agreement. I don't show up. Okay, I just totally broke my promise to him. Okay, can he sue me? No. Okay, what would he sue me for? A contract is an agreement that can be enforced. Okay, it can be legally enforced. Okay. How would Devin enforce my contract? I mean, morally, ethically, I'm a bad person for standing him up, but there's nothing a judge can do. Okay. So I had a woman who took business law from me at night many, many years ago. And I wish I had kept in touch with her because I wanted to know what happened with her marriage, but she was engaged. So she came up to class one time and asked me something. She was engaged to a guy from Iran. And a lot of her friends were telling her, he only wants to marry you to get a green card. Okay. I think secretly she had those same concerns. So she asked me, could I write a contract that says, if we ever get a divorce, he will deport himself back to Iran. Okay. Now I told her, I said, you can write any old contract you want to. Okay. That doesn't mean a court will enforce it. Okay, and a court wouldn't touch that. A court's not going to force a guy to go back to Iran. So a contract is an agreement that's legally enforceable. Okay, now, there is a virtue sometimes in having fake contracts sometimes, okay? So my nephew, when he was like 8, I had him sign a contract basically saying I will reward him with certain grades with money, okay, certain amount per letter grade, okay? And we have a contract that says that, okay? Now, of course, that contract's not enforceable because he's 8. What's the point of entering into that then? It's totally unenforceable. He could not force me to pay him the money. What's the point of it? I mean, morally, I'm going to pay him because I said I wouldn't. He's my nephew. But what's the point of having an 8-year-old sign a contract? I mean, it's not a legal point. Yeah, Devin?
It's a mindset.
Yeah, that's it. It's just to drive home, this is serious. And I had him sign it, and I kind of explained to him what a contract is. I didn't go into the details about how it's not enforceable. But I kind of want to make it serious. Sometimes romantic couples may have a contract. Okay, I'll do the dishes Monday, Wednesday, Friday. You do them Tuesday, Thursday, Saturday, right? Like sometimes it helps to have these little contracts just to put things down in writing so we're all on the same page, but that doesn't mean it's enforceable. So a contract is an agreement that's legally enforceable, okay? Now, how do we know there's a real contract or not? We look at what the parties say objectively, meaning what would a reasonable person think they meant, okay? So I'll make up a fake hypothetical. Okay, Devin's taking a class on campus. Okay, I'm on campus. I just bought a brand new $200,000 Bentley. Okay, I'm walking out to the parking lot. I say hi to Devin. Devin's car won't start. And I say, do you need a ride? And he's like, yeah, could you give me one? I'm like, yeah, come on and get my car. I'll take you to where you need to go. So he gets in the car and my car won't start. I'm like, I hate this car so much. I'd sell it to you for $5. And Devin says, I accept. Okay. Now I offered him the car for $5, right? Why is that not a valid contract? and he said, I accept. Why? That he could not enforce that contract against me. Yeah, Devin?
Would it be consideration?
Well, it's not a question of fairness. Remember, courts don't question whether a contract is fair. You are giving me something in return for something. But what about intention? Do you think I really meant what I said? Would a reasonable person think I'm really selling you that car for $5? No, because I said it in frustration, just under the circumstance. Also, is the price obviously a joke? Yes. Okay. Now, if I said, Devin, I hate this car so much, I'd sell it to you for $195,000. Yeah, if I said that, then is that a real offer? I mean, is that more plausible because it's near the purchase price? Yeah. Okay. So whenever there's a confusion about is there an agreement or not, a court will ask, what would a reasonable person? And in the Lucy versus Zamer thing, the court said a reasonable person would think that a 45-minute discussion that led to something in writing signed by both the husband and wife, that looks to me like a serious contract. Okay. Now, what happens if after a contract is signed, one of the parties dies? In general, the contract is still enforceable. Okay, after your death, your estate will now become responsible for the contract. Okay, so in reality, let's say I sold my house to Devin. While we are in escrow, Devin dies. Okay, I could file a claim with his estate to get paid for the house. So his estate would inherit the house, but the estate would still have to buy the house. I could force his estate to buy my house because he signed a contract. Now, what that would mean is if there's enough money left over after he dies, like in savings account or whatever, I can put a claim on them to pay me for the house. And then the estate will take ownership of the house, and the estate can then sell the house later on if they wanted to. Now, in reality, I'm probably just going to let it go if he actually died during escrow, but I don't have to. Okay. So that's just something to note, that your contractual obligations last after you die, but your estate is responsible for paying them. And if the estate doesn't have enough money, then the estate doesn't have to pay. Okay. Now, a personal service contract would mean this. I hired Devin, who works for Michael's brokerage, to sell my house. And I hired Devin because he's great and I really like working with him. Okay. Devin then dies in a car accident while he's out there working for me. Can Michael force me to work with Kenny, who is another agent that works for Michael's brokerage? No, because I hired Devin. Right? Like the point of my contract was Devin, who happens to work for Michael. I didn't really hire Michael. It's just I hired someone. So that's called a personal service contract. In that situation, I don't have to keep working with somebody else from Michael's brokerage. Okay. I think in general, most of the time when a death occurs in the middle of a contract, usually the parties figure out a way to resolve it. Okay. Okay. Now, what makes up an agreement? Well, the answer is an offer and an acceptance. That's what makes an agreement, an offer and an acceptance. I offer to sell you my car for $10,000. You agree to buy my car for $10,000. The person who makes an offer is the offeror. That's a real word. And the person who receives the offer is the offeree. Kenny, I'll sell you my car for $10,000. I am the offeror. He is the offeree. Okay. Now, an offer is only an offer if it's made to one person. Okay. So I said, Kenny, I'm offering you blah, 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 blah. That's an offer. If I said, hey, class, I'm selling a 2010 Honda Accord for $10,000. That's called an ad. Okay. And an ad is not an offer because it's not made to one individual. So an offer is only an offer if it's made to one person. Okay. Otherwise, it's an ad. Now, The reason why ads aren't offers is because ads can be accepted by many people. All of you tonight could say, oh, I want to buy your car. And I can only sell it to one of you because I only have one car. So when I put out an ad, what I'm basically telling you is make me an offer. Make me an offer to buy my car. Okay, make me an offer to buy my car, and you know, and then basically what I'm looking for is for you to tell me, yeah, I'll buy your car, and that is you making an offer to me, and then I'm free to accept it whether whether I want to or not. So, like, let me give you an example. I'm not explaining this very well. But yeah, Foma, what were you going to say? You're mute.
Can you hear me?
Yes.
Hello?
Yes, I can hear you.
Okay. Okay, I was going to say that I see this a lot with agents that for leasing. Usually when you're trying to get a house or a place, you know, they'll put out offers for several people to come and check out a property for leasing, and then they'll invite like over 50 people, and then you have to pay like, you know, maybe like $50 or something for them to check your credit. But what I find out is that sometimes they already have who they want to give it to. That has been my experience with offers, you know, in the past. I don't know if
Well,
it's also
okay, so when they're advertising, come take a look at this apartment or home for rent, that's an ad. And what they're saying is,
yeah,
hey,
the
public,
ads, yeah.
they're saying, hey, public, come make us an offer at this rent. Okay. And then they can pick whose offer they want to take, as long as, by the way, it's not like on discriminatory grounds or something like that. But you're right. I can't explain that behavior. If to me, if you know who you want to rent this place to, why bother advertising it? You don't have a legal obligation to advertise it. So to me, that's a bit of a strange behavior. But what I was going to say was, go ahead.
I was just going to say that they do this, especially in, you know, the SF area. They do this a lot because housing is so difficult to get, especially
Yes.
leasing. So they
Yes.
just gather a lot of people together, you know, bring like 50 people to an open house, and then they already know who they want to give it to, but they are still collecting your money just to, you know, view the place. So when you said
Yeah.
ads and yeah, it
I
kind
mean,
of
I can't explain that other than it does seem to be trying to take advantage of other people. Monica.
I think they do that just to have backups.
It could be, but then you get people's hopes up, right?
Yeah.
But you're right, and it doesn't hurt to have backups. Michael.
Is it kind of like a bid kind of bit? Like trying
It is like a bid, yes. What I was going to say was what if I actually did this like 2009 when last time I sold a used car. I put a used car on Craigslist and I said, you know, used car, here's the price. Within 8 hours, I had 20 offers. Okay. So when I put this ad up on Craigslist, I'm basically saying, make me an offer. And I had 20 offers within 8 hours. Am I free to reject all those offers and just change my mind, not sell the car at all, or repost the ad at a higher price? Because that told me I wasn't charging enough. Okay. Yeah. Because I never made an offer. Okay. But if Michael says, Lance, I'll buy your car for $10,000, he's making me an offer. And then I can decide whether I want to accept it or not. Just because someone makes you an offer doesn't mean you have to accept it. Okay. But ads are not offers. They are requests for offers. Okay. Now, can an offer be withdrawn? The answer is yes, as long as it hasn't been accepted. So remember that. An offer can always be withdrawn as long as it hasn't been accepted. Okay. So if Michael makes me an offer for whatever, the $10,000 for the car, he can change his mind, but he better do it before I accept his offer. Because once I've accepted his offer, he's locked in. Okay. If you are, so going back to like FOMA's real estate experience, if you're bidding on buying a home and you submit an offer and you later realize, you know what, I don't want to buy that house. I think I found something better. You better withdraw that offer real quick. Because if your offer is accepted, you're stuck, you're in contract. So when you make an offer, you're basically saying, I'm willing to be committed to you if you accept my offer. And if you don't want that, then don't submit an offer or withdraw the offer. Okay. Mailbox, yeah, June.
What if I call, I say I want to withdraw my offer, and the other side say, oh, I'm just about to call you, I accept your offer.
Okay. Well, the way you phrased it, June, you canceled first. You withdrew the offer first. But this is you give me a hypothetical I sometimes use in business law. Okay, so what about this? I tell June that I'm offering her my car for $10,000. She wants some time to think about it. And I say, that's fine. When I see you at work on Monday, just tell me by 10 a.m. on Monday whether you want my car or not. Okay. And she's like, okay. So it's Monday morning at 8 a.m. Now, Sunday night, June had laid in bed saying, you know what? When I see Lance tomorrow, I'm going to tell him I accept. And I'm laying in bed Sunday night thinking, you know what? I don't want to sell the car to her. When I see her, I'm going to tell her I revoke, I cancel the offer. Okay. So we see each other in the parking lot Monday morning and we're waving, and June is polite. She says, good morning, Lance. How are you? And I say, shut up, June. I accept your offer. Or sorry, I revoke your offer. Okay. Then there's no contract. But if June is rude and she's like, shut up, Lance, I accept your offer, we have a contract. So it's whoever acts first. Okay, now that's kind of an extreme example, but that's how it would work. Okay. Mailbox rule. An offer is considered accepted as soon as the acceptance is sent. Okay, meaning like you click send on your email. Okay, or you put a letter in the mail. But if you're withdrawing an offer, it's only effective when it's received. Okay, not when it's sent, but when it's received. So let me give me just a second. You make me think of, I just thought of something I could show you that might make this a little bit easier to understand. Let me just see if I have it in my files, but I think I do. Just a second. So let me just say that again. An offer can be accepted the moment it's sent, like put in the mailbox, or you click send on your email, or you hit a fax send button. But a revocation, a withdrawal, is only effective when the offeree receives it, and you've got to prove they received it. So let me give you an example, okay? And this is a real estate case. A seller made an offer to this investment company to buy an apartment building. And the investment company decided, we want to buy it. So they gave their administrative assistant a letter to take to the post office to say, we accept your offer. They gave it to their administrative assistant at 10 a.m. But the assistant didn't get to the post office until noon. So the acceptance letter was postmarked noon. Hold on, I'm about to joke there. So at noon is when the acceptance letter went out. But while the administrative assistant was out running around, the sellers called at 11 a.m. saying, we revoke. So is there a contract? The acceptance letter went out at noon, but the revocation came in at 11 a.m. No contract. Okay. So just communication is really crucial in these kinds of situations about when something comes in or when it goes out. Okay. We could talk a lot more about the mailbox rule, but I think that's enough. Okay. Acceptance. Okay. So, and we talked about offers. Okay. Now let's talk about acceptances. An acceptance, first of all, an acceptance has to be clear and unequivocal. Okay. It can't be vague or implied. So what about this? Monica tells me she wants to sell her house, and I say, hey, Monica, I can do that. I'll only charge you 2%. And Monica says, that sounds good. Is that an acceptance? Maybe, but maybe why not? What am I getting at? Maybe it's an acceptance, but maybe not. Why not? What's the problem with it? A court would not hold that to be an acceptance. Why? So I say, hey, Monica, I'll sell your house for you for 2%. She says, that sounds good. Yeah, Monica?
It sounds like just conversation.
Exactly. When she says that sounds good, does that mean she accepts my offer? No, she may just say like, oh, that sounds like a good rate, but that doesn't mean she wants to hire me. So when you accept, it's got to be explicit. Okay. Now, what I would say is if she says to me, oh, Lance, that sounds good. At that point, I would say, I would want to clarify, like, so does that mean are you accepting my offer or not? Like, can we put this in writing? So you don't want to leave these things kind of vague. Okay. Because if you leave them vague, that leads to misunderstandings. All right. Silence is not acceptance. Okay. So you cannot force someone to accept. You can't say like this, hey, Monica, I'm offering you my car for $10,000. If I don't hear from you by tomorrow at noon, we got a deal. Okay. No. Okay. Silence can't be acceptance. The only time it can be acceptance is if you and I agree in advance. So like, hey, Monica, I'm offering you my car for $10,000. And Monica says, let's assume I'll buy it unless you hear from me by Friday at 8 a.m. Okay. I don't hear from her by Friday at 8 a.m. What does that tell me? So she said, Lance, let's assume I'll buy it unless I hear from you at Friday at 8 a.m. I don't hear from her by Friday at 8 a.m. What does that tell me? Yeah, phone.
It means she's not interested. It's not a concluded, like it's not
No,
explicit.
but
It's
she
not an
said,
explicit
you're right, it's
offer.
not explicit, but she said, let's assume I'll buy it unless you hear from me. Did she hear from
So
me?
no,
Did I hear from
you
her?
don't hear from her.
So what does that
No.
tell me? No, it tells me yes, she wants the car because she said, let's assume I'll take it unless you hear from me. Did I hear from her? No. That
No.
tells me she accepts. Right? She said that. If you don't hear from me, that means I accept.
Oh,
Right?
okay.
She said,
Okay, now I
let's
get
assume
it.
I'll take it unless you hear from me. And I didn't hear from her. But that would be the only situation where her silence would be acceptance. Normally, silence isn't acceptance. Okay. Mirror image rule. When I make you an offer, it's all or nothing. You accept all of it or none of it. Okay. Yeah, Monica.
Let's go back that previous example, but it
Okay.
says let's assume I'm buying it, but then it's just a talk too, right?
You mean it's an oral contract? Is that what you mean?
Yeah.
Okay. Yeah, you're right. We would need to get that in writing. Yeah. But if it was like a car, if it was a car, it doesn't have to be in writing. But ideally, it would be in writing. You never want to leave things open-ended like this because it becomes a mess. And so it's much better to formalize everything in writing if possible. Okay. Michael.
I just want to make a comment that I think you're on the agreements and consent slide, and I think that acceptance is the next slide on 57.
Oh, sorry. Thank you. Yeah, you're right. Thank you. Thanks for pointing that out. Okay, so silence can't be accepted. If I tell you, hey, Michael, I'm offering you my car for $10,000. If you want to accept my offer, text me at this phone number, I accept. Okay. Michael, instead of texting me, calls me and says, hey, Lance, I accept. Is that a valid acceptance? No. Why not? Yeah, Devin?
Because it's verbal, nothing was written down.
Well, it's also because I told him to text me. Okay.
True, yeah.
He hands me a handwritten letter saying I accept. Is that valid? Nope.
Does it outline the terms though?
It doesn't matter. I told him to accept via text.
Okay, all right.
I control how he accepts. And if he doesn't follow my rules, then I don't have to accept it. Okay. So when the offerer tells you how to accept, you got to follow that rule. Okay. And if you don't, it's no good. Now, if I just say, Devin, I'm offering you my car for $10,000. If you want to accept, get back to me in writing by Friday at 5 p.m. Okay. Then that gives you the option of texting me, emailing me, hand delivering a note, whatever. But if I say, Devin, if you want to accept my offer, text me at this number by 5 p.m. If you don't text me at that number by 5 p.m., the acceptance is no good. Okay. So I control how you accept. It's up to me. Okay. Do you follow? You look troubled. You got it? Are you troubled by that, Devin? You look troubled. No. Okay. All right. Carmen.
Okay. What I understand is you had to follow what the buyer, what the
What the
seller
seller says.
offer. Yeah.
Yeah. Mm-hmm. That's right. Whoever makes the offer controls how it is accepted. That's correct. Michael.
So basically, it just set up instructions in order to follow with the offer that's being made by the seller.
That's
because
right. And
the instructions.
I can be super specific, like you must write back via text, or I could just be get back to me tomorrow in writing. Right. So it's up to me. I call the shots. Okay. Devin.
No, when you were asking if I was puzzled, I was just thinking for a second. I mean, how legitimate is that a text me yes or no? I mean, for all I know is you could have sent the text, and on my end, I could have been like, well, somebody else offered me something else. I'll just tell him, I never got your text and accepted somebody else's offer.
Yeah, I don't have a good comeback to that. You're right.
Because
it's not ideal.
Okay.
It's not ideal. Yeah. All right. Okay. Mirror image rule. An acceptance has to mirror the offer. If I make you an offer, it's all or nothing. You accept all of it, or it's a counter offer. Okay. So what if I said this? Okay. Hey, Devin, I'm offering to sell you my house at 123 Main Street for $1 million. Escrow closes October 30th. We'll use ABC Real Estate Company to do the transaction. And we will meet at the Starbucks on Los Gatos Boulevard on October 30th to sign the paperwork. Devin writes me back, Lance, I accept your offer. I love it. I'll buy your house at 123 Main Street for $1 million, closing on October 30th, using ABC Company, and I'll meet you at the Pete's on Los Gatos Boulevard on October 30th. Has he accepted my offer? Nope. He made me a counter offer. I said at the Starbucks, he said at the Pete's. Okay. He did not accept my offer. He made me a counter offer. So what he's basically saying is, no, Lance, but I'm going to make you an offer to buy your house for $1 million October 30th, et cetera, et cetera. But instead of Starbucks, we meet at Pete's. And then it's my decision whether I want to accept his new offer. So when I make you an offer, it's all or nothing. You can't pick and choose what you like in my offer. So think about this. In the textbook, there's the California Association of Realtors Standard Purchase Agreement. It's 10 or 8, I think it's 8 pages, single-spaced, 10-point font. It is packed with detail. Is there a good chance when I send that to Devin that while overall he's happy with my offer, there's a few things he wants to tweak? Yes, and he makes me a counter offer. A counter offer is when you reject an offer and at the same time make a new offer. So originally I was the offerer and Devin was the offeree, but Devin rejected my offer. So he's now the offerer and I'm the offeree. So what he might say is, Lance, I love your offer. Everything is great, but I want to change the place where we sign the closing papers. And so that's a counter offer. And he doesn't have to restate my entire offer. He just says, Lance, I accept everything but the place we meet and I propose it be this. And then it's my turn to accept that offer if I'm okay with moving it to a different location. So just realize that when you make someone an offer, they have to accept it 100%. And if they nitpick at it, what they're doing is making a counter offer. And then what that means is they rejected the old offer and they're making you a new offer. Okay. So mirror image rule is an acceptance has to mirror or match the offer, meaning all or nothing. Okay. Now let's talk about how long does an offer last? Okay. So I make Devin an offer to buy some commercial property I own for $2 million. Okay. That's not a light transaction, right? Devin really needs to think, first of all, financially, can he swing it? Is it an investment he wants to make? Does he want to get tied down with that much real estate? He really needs some time to think about it. And so he says, Lance, can you give me some time to think about it? And I'm like, you got it. Okay. What is the danger if he asks me, Lance, can you give me some time? From Devin's point of view, what is he risking? He says, Lance, can you give me some time to think about it? And I'm like, yeah, you got it. What is the risk of him asking for time? Yeah, Devin.
More potential buyers.
Yep, I could find someone else like Kenny offers me more than you do, and so I call Devin, say, Devin, I withdraw the offer. I've sold it to Kenny. Or I could just say, I decide I don't want to sell it at all. Okay, so there's a risk there. How long does an offer last? Generally, the answer is a reasonable amount of time. What is reasonable depends upon what is being offered. If I offered Devin a box of oysters, unrefrigerated, I think Devin has like 30 minutes to think about my offer. But if I'm offering him a $2 million property, I think he would have at least a week to think about that. Now, we could get into arguments about how long he has. The best way to address this is for me to tell him, when he says, Lance, can you give me some time to think about it? I say, yeah, I'll give you 1 week from today. Right? That way, Devin has a deadline and he knows, what does it tell me if I don't hear from Devin within that week? What does it tell me? I made him the offer. He said he needed time. I said, you got it. I'll give you till a week from today. What if I haven't heard from him by next Friday? What does that tell me? Yeah, Michael?
It means that maybe he's not interested in the deal.
Yeah, and I can move on. It's basically telling me no. Now, there's nothing stopping him from Thursday calling me and saying, Lance, I know I'm supposed to give you an answer tonight, but I've got some complications. Can you give me a few more days? Then we can agree or disagree whether I'll do that. Okay. Okay. Know that I can always revoke the offer until it's been accepted. Okay. I can always revoke the offer until it's been accepted. And if he rejects the offer, it's dead. Okay. So what about this? I offer Michael my used car for $1,000. Michael's trying to bargain with me. He's really willing to pay me $1,000, but he's trying to see if he can get me to go lower. And so he says, no, Lance, I'll pay you $900. And I say, forget it. And Michael's like, okay, I'll pay you $1,000. He can't do that because he just rejected my offer. And so when he said, no, Lance, but I'll pay you $900, boom, it's over. He can no longer accept my offer. And so when he says, okay, I'll pay you $1,000, what he's doing is making me an offer. Okay. Because he killed the previous offer and he can't accept it. Okay. Okay. An offer can be contingent on something. Okay. Paul, I'll hire you to work at my company if you pass a background check. Monica, I offer to buy your home at $1 million, assuming it passes a termite inspection. So if Monica's house fails the termite inspection, then my offer evaporates. If Paul doesn't pass a background check, my offer evaporates. So my offer can always be contingent on something happening. A lot of times in real estate, it's contingent on me getting the loan, me getting the financing. So it just depends on how it's phrased, okay? If the offeror or offeree dies before the offer has been accepted, the offer is dead. It's no good, okay? And then if I make you an offer for something and you're thinking about it, and while you're thinking about it, the offer becomes illegal, like a change in the law or something like that, then the offer is no good. So let me give you an example. So San Jose has zoning where marijuana businesses can go. And the zoning used to be a lot broader. San Jose kind of tightened the rules, I don't know, about 10 years ago. But let's say that I made Monica an offer to lease a warehouse building I have for her marijuana business. While she's thinking about it, San Jose changes the laws. And now that warehouse business is located in a zone where marijuana businesses are not allowed. Then my offer is no good because the offer was for a transaction that has now become illegal. Okay? That's kind of a weird situation. Okay, I tell you what, let's take a break, and we'll go through some more fact patterns. I think at the rate we're going, I mean, we'll decide like at the end of the night, but at the rate we're going, probably the midterm's going to be next week in the second half of the class. So we'll finish up contract law next week, and then we'll do the midterm the second class. But we'll see how far we go after the break. Okay, so let's meet back at around 3 after 9. Okay, so go stretch your legs. Okay. All right. Okay, so there was, so just as a refresher, there's, in order for there to be a contract, you have 4 elements. We've talked about capacity. We're on agreement. And one last thing in an agreement is, when is an agreement not valid? Okay. So we talked about, for example, is it a joke, right? Like, is it an obvious joke? So when Devin says he's going to buy my Bentley for $5, we know that's not really a valid agreement. Yeah, Michael?
Can an agreement be a set of very too specific like elements? Like let's say someone says, I want to buy a Chevy 2007, for example, and they're like, oh, let's go to you gotta go to McDonald's, you gotta order this specific meal and meet me in the corner. Can that be seen like as a joke or something like that? Or
It depends on the eye of the beholder, is what I would say. So it just depends. But I think the harder you have to argue to convince someone it's real, the harder generally a court's going to, if a reasonable person agrees with you, then you'll win. That's the thing. Everything is judged by what would a reasonable person think. And that can be vague sometimes, right? So like when I told Monica I'll sell her house for 2%, and she said that sounds good, you could argue that means she accepts, but would a reasonable person automatically think that? It may just be like, hey, that sounds good, let me think about it. It's not clear what she's saying to me. So when in doubt, get it in writing or get it specified as to what's going on. Okay, now, yeah, Ofoma.
So I have a question about like contracts when it comes to like what you just said, an agreement, whether it's legitimate or not. An example would be at will contracts when it comes to work, like a job in the state of California, for instance.
Yeah.
For example, you start a job, or before you start a job, there's a contract, there's a contractual agreement for you to
Yeah.
start the job. And there's an agreement that, oh, you're going to be paid a certain amount of wages, and you accept that. But along the line, the employer or the employee decides to change the terms of the contract. If the employer decides to change the terms of the contract, for example, and it's still at will, does that law void or is it valid, especially if
Well,
there's not a new agreement?
So employment's tricky. So first of all, if there is a written contract guaranteeing a salary, that contract has to be honored for the time frame that it says. Okay. Employment in general is at will, which means you are free to quit with no notice, and your employer is free to lay you off, meaning they can show that they can't afford you anymore, or they're not making that software anymore, or something like that. There are what are called implied contracts in the law, which basically is you can't be fired for reasons unrelated to your performance. And so even though your employment is at will, which means you could be laid off at any moment, you cannot be fired, because under the law, courts basically say that it's implied in any employment arrangement that you should only be terminated for cause, for doing a bad job, not for arbitrary reasons. So, but if you have an employment contract in writing, that cannot be changed during the time frame it's active, right? But after the time frame it's active, then it can be changed. So like if it's a 1-year contract, things can change after 1 year.
Okay, got it. So I'm just like trying to, put this in the context of voidable contracts. So can the maybe employer just change the wages, or do they have to bring a new contract
New contract.
based on
New
a
contract.
new contract?
Yep,
Okay.
a new contract. That's right. And they and by the way, they could pay you to terminate the old contract, saying, hey, look, Foma, we want to renegotiate your salary. We'll pay you $50,000 if you cancel this contract early, right? And so
Okay.
that can be negotiated also. Okay, now, what is an agreement that is not valid, even though it looks on the surface to be valid? Okay. I am trying to sell Foma my car. She asks how many miles it has on it, and I say 50,000. That's actually a lie. It has 100,000. But what she doesn't know is before she came over to look at the car, I got in there and rolled the odometer back. Okay. So we have a contract. She's buying my car and she's going to give me the money. I'm going to sell her the car. The problem with that contract is she's not getting what she thought she was going to get. So, and because I lied to her, that's an invalid contract. It's not enforceable if she can prove that I lied to her. In a real estate contract, if I was selling her a house and I lied to her about termite damage, the contract is no good because she entered into it pursuant to a lie, right? Her agreement really isn't valid if I got her agreement by tricking her, okay? So fraud makes a contract invalid. Mistake. If both parties to a contract make a mistake, the contract is no good. So I offered June my car for $5,000. She agreed to buy my car for $5,000. What I didn't know is that an hour ago, it was just totaled by a drunk driver when it was parked on the street. I didn't know that. June didn't know that. We both made a mistake. The contract is no good because we both made a mistake. Okay. So this is an interesting case I read about. A couple owned two properties, one in Petaluma, one in Sebastopol. This is both up in Sonoma County. The couple was taking out a loan and they pledged their property in Petaluma as collateral for the loan. Okay, so what they were doing was they were taking out a loan on their Petaluma house. Okay, and that's very common, like if you do a refinance or something like that. So they were taking out a loan on their Petaluma house and they put the Petaluma house as collateral. But when the bank sent them over the loan documentation, someone made a clerical mistake. And instead of including the legal description for their Petaluma home, they put the Sebastopol. And so, and the bank even said, here's the legal description for your Petaluma home. Please sign where indicated. So they signed where indicated. Then later, that they weren't able to pay back the loan and the loan went into foreclosure and they discovered that the loan documents referenced the wrong property. And the court said, since both were operating under the assumption that the legal description was for the Petaluma property, when in fact it wasn't, the whole loan agreement is invalid. And what that meant was the bank couldn't collect the debt. That because they had not put up the right collateral and it was the bank's mistake. And the couple didn't know it was a mistake either. Because as I mentioned way back several chapters ago, most people don't even know how to read legal descriptions. And so the couple got lucky. They didn't have to pay back the loan because of this mistake in paperwork. So like paperwork matters in these transactions, okay? Duress. I tell Monica, hey, Monica, buy my car for $5,000. She says, no, I'm not interested. And I put a gun to her head and I say, no, I think you are. So she signs the paperwork, okay? Now that looks like a valid signature, right? Except that is it really free will? Did she really agree to this? No. And if she can prove that I like forced her into it, it's not a valid contract, okay? Undue influence is where you are not forced into a contract, but you let your guard down and you enter into a bad contract because you were doing business with someone you trusted. So for example, Michael's considering buying a used car from me and from his mom, okay? If he buys the car from me, he's going to have a mechanic check the car out. but he decides to buy the car from his mom and he does not have the car checked out. Okay. That's a bad idea, buying a used car with a mechanic without having a mechanic check it out. And it turns out Michael's mom lied to him about the condition of the car. Had he had a mechanic check it out, he would have discovered all these problems. So was he sloppy in not having a mechanic check out his mom's car? Well, okay, Michael's saying, yeah, but I'm like, no, you weren't. I think you're being pretty harsh on yourself. Why? It would be sloppy if you didn't have my car checked out. But why would we cut Michael some slack for not having checked out his mom's car? Just think about it. This should not be hard. Think about this. Why is it understandable Michael didn't have his mom's car checked out? Okay, let me put it another way. What's the difference between doing business with me versus his mom in terms of trust? Yeah, Michael.
It's because my mom's a relative.
Would it be understandable that you think you could trust her?
Yeah.
Okay. Undue influence is where someone uses the trust they have with you to take advantage of you. So put it this way. Could his mom easily take advantage of him, whereas I would have a much harder time taking advantage of him? Undue influence is where you try to cancel a contract with someone you trusted because they took advantage of your trust. Okay. And did you have a question, or were you? And oh, you're mute. You're mute.
The question's being answered. So, yeah.
Okay. So let me give you some examples of this, of what undue influence means. A will, by the way, a will is not a contract. Okay. But in California, a lawyer cannot write a will in which the lawyer gets something. So when my mom wrote her will, I couldn't help her. She had to pay a lawyer to do it. But that's a good law. Why? What is the problem with me writing my mom's will? Even though, I was perfectly capable of doing so. Why is that? Why can't I write it? Think about this. If my mom, Anne, what were you going to say? You muted yourself accidentally.
It would be a conflict of interest.
Well, think about it this way. If my mom hired Anne to write her will, that's just a business relationship. She's going to tell my mom, she's going to tell Anne, here's what I want done. But do you think she's going to double check Anne's work? Yeah. She has me write it, and I say, hey, mom, I'll take care of it. You can trust me. It'll be all good. Is she less likely to read it since her son wrote it? Yeah. And could I write things that are to my advantage? Yes. And so that's why legally I couldn't write her will. Okay. Because my mom is just not going to pay as much attention. Okay. Did you have a question, Anne? Okay, you're here. So undue influence is where you just make a claim the contract's no good because a person abused their position of trust with me. Okay. So this is a crazy case I read about from the 80s. There was a guy who was a veteran. Okay. And if you're a veteran, there are a lot of cool loan programs the federal government offers you to help you afford home ownership. So there was a guy who qualified for a veteran's loan, but you still have to have a down payment, and he didn't have the down payment. So he went to his parents and said, hey, mom and dad, if you give me the down payment, I will qualify for this veteran's loan and I will buy a home, and I have to buy it in my name only. That's just the terms of the veteran's loan, but I will let you guys live there till you die, and then I'll move in afterwards. Okay. Well, the parents understandably wanted to help their son, so they agreed and gave him the money. Okay. And they had a contract where they could stay there until they died. They moved in after escrow closed, and then a couple of years later, they had some disagreement and he kicked them out. He evicted them. Okay, nice guy, right? So they're like, wait a minute. He can't do that. Okay. Now, let me ask you this. If Anne came up to me after class and said, "Hey, Lance, I've got a deal for you. Give me 20% down payment, and then I'll buy a home, but I promise to let you live in the home until you die, even though I will own the home." What am I going to tell her? I mean, like, are you out of your mind? Like, there's no way I would do that, right? You would be a fool to do that. Why then did they do it? Were they stupid? Or they weren't stupid? Why did they do that? Why would they do such a crazy transaction with their son? Think about it. Yeah, Monica?
Because he is their son. So.
That's it, right? Say no more. They did this transaction because they trusted their son. And was it reasonable to trust their son? Yes. Would it be reasonable of me to trust Anne or Monica or Devin or Michael? I mean, no offense to any of you, but no, I don't even know you, right? Like, that would be crazy. But we understand why they did it, because it's their son and they assumed he would look out for their interest, right? Okay. All right. Now, let's move on to the last two elements.
It's a sad story, then.
It's a very sad story. I'd love to know whatever happened and like what went down between the son and the parents, right? Okay, legality. If a contract has an illegal purpose, it's no good. If I hire Monica to murder my neighbor and I pay her $10,000 in advance and she doesn't murder my neighbor, I can't take her to court. Like, no judge is going to help me out on that. So a judge will not enforce an illegal contract, right? Consideration. Both sides in a contract have to give something up. And unless both sides give something up, it's not a contract. So I email Monica this so she has it in writing. Monica, you've been a great person. I'm going to give you $5,000 because you're a great person. Okay? Can she, I promise in writing to give her $5,000. Can she collect that money from me? No, because what did she give me in return for my promise? Nothing. And so when someone makes you a promise, you have to promise something to them. And if you don't, it's not a contract. So if I said this, Monica, if you bring me an apple to class on Monday, I'll give you $5,000. Is that a contract? It is, because I'm giving her money and she's giving up an apple to me. Okay. So remember, the contract doesn't have to be fair. It's just that both sides have to give something up. It can also be this. Monica, if you agree not to wear a red shirt to the next class, I agree not to wear a blue shirt to the next class. That's a contract. Because are we both giving up something we have the right to do? Yes. Okay. So it could be, I could pay you not to do something that you have the right to do. That's a valid contract. Okay. So just really, it could be, I'll wash your car if you mow my lawn. Okay. I won't sing in the shower if you won't smoke cigarettes. Whatever. It's just, if both sides aren't giving something up, it's not a contract. Okay. So there has to be some exchange of value. But again, remember, it doesn't have to have equal value. Okay. Now, if you go back to this slide, the elements of a contract, the one I forgot to mention was writing. Okay. In general, writing is not a required element of a contract, except in real estate. And in real estate, just remember that contracts have to be in writing. And by law, there's 5 kinds of contracts that must be in writing. Anything related to real estate, anything that can't be completed in under a year, meaning a contract that is set to last longer than a year, that has to be in writing. Promises when you guarantee somebody's debt, okay, like you co-sign for somebody. Marriage-related contracts. I don't mean arranged marriage contracts. I don't mean that. This means prenups. Prenuptial agreements have to be in writing, okay? And then the sale of personal property, but that's not something that's relevant to this class, okay? Now, one other thing about writing that's important is the parole evidence rule, okay? Do contracts sometimes take weeks of negotiations, right? Both oral and written, like via email and talking, okay? The parole evidence rule is a rule that says this: whatever document the parties sign, that's the final word. And so anything that happened before that final word doesn't matter. What matters is, what does the written contract say? Okay. And so if you sign a written contract and you later say, wait a minute, that doesn't match what you and I talked about 2 weeks ago, it's too late to raise that. The moment you sign the contract, that's it. Okay. So a court will not let you bring in evidence outside of the contract itself, as long as the contract is clear. Okay. So like, let me give you an example. I'm negotiating a lease with June. Okay. And we're negotiating via email, which is good because we have a paper trail. Okay. Because of her pay salary, she wants the rent to be due on the 15th of the month. And I'm cool with that. And so she has my email correspondence saying, yes, rent will always be due on the 15th of the month. So we reach an agreement via email, and I send her the final draft of the lease. And the final draft for her signature says rent is due on the 1st. So she emails me saying, Lance, everything looks good, but we agreed the rent would be due on the 15th, not the 1st, remember? And I write her back, oh yeah, you're right. I'm sorry about that. This is a standard lease that I forgot to update. But because of this email, you have my word that where the lease says 1st of the month, it really means 15th of the month. So she goes ahead and signs it. Okay. The first month comes around, she doesn't pay me by the 1st of the month. And I call June and I say, where's the rent? And she said, well, you know where it is. I'm not going to pay you to the 15th. And I say, well, that's weird. I've got a lease here that says you're going to pay me on the 1st. Mm-hmm. Who's going to win in court? I'm going to win. Because when she tries to show our prior email correspondence, the judge is going to say, too late. It's too late to bring in that outside evidence. You shouldn't have signed it if this is not what you want. And think about it. In the modern era, is it incredibly easy to change legal documents, with word processor, right? So when she saw that the lease said 1st of the month, she should have insisted that I change it to 15th of the month. And by signing it, it's too late. All right. So just remember, a court will not look at anything except the final contract itself. The only exception would be if the contract is unclear. So what if the lease said rent is due on the blank space of the month? Then would they want to see June's emails? Yes, but only if the judge can't figure out what the contract itself means. So the moral of the story is never sign a contract that is not exactly what you want it to say. And it's easy to change a contract to make it exactly what you want it to say, because you don't get to redo it after you signed it. All right. And that's just called the parole evidence rule. All right. I will tell you, so I had a woman who took this class years ago when we were doing it face-to-face, and she was a relocation consultant. So she works with tech companies on helping new employees kind of navigate the Bay Area, kind of understand, what they can afford, school districts, commute patterns, et cetera. Now, I'm going to make up the dates because, to be honest, I don't remember what the dates were, but she was working with clients that wanted to enroll their kids in Saratoga schools. But the problem was they were not going to move in until January. And if you wanted your kids to go to Saratoga schools that academic year, you had to show that you were living in Saratoga before December 31st. They were looking for a place to live in November. And when they found a house they liked in Saratoga, they told the landlord, we're not moving in until January 1st, and we're not going to pay rent till January 1st. And the landlord said, that's fine. But then they said, but could you backdate the lease so that it says December 1? Because we need to show the school district that we're living here as of December. So the landlord's like, yeah, no problem. So the landlord backdated the lease, they signed it, and that was in November. Remember, they're not going to move in until January. On December 1, the landlord calls them and says, where's the rent? And they're like, well, we're not paying you till January. And what's the landlord say? I got a lease saying you're paying me on December 1st. Do they have to pay it? Yeah. The landlord totally tricked them. Okay. I don't feel totally sorry for them because they were kind of trying to cheat the system also, but you know, it is kind of sleazy what the landlord did. So that was by the way, this is why I love participation in classes, because I learn stories, I learn things from people. So, you know, if you ever like have a story you think is relevant, you know, please share it with me, because I find that stuff kind of interesting. Okay, now, let's do one more slide and then I think we'll call it a night, just because we've covered a lot tonight. Okay. Contract, you know what? No, let's stop. Okay. So let's talk about next week. Okay. I want to give you a sense of how it's going to work next week. I will cover the remaining slides. Okay. Yeah, I will cover the remaining slides starting at 6:50 p.m. Okay. And then there is a review sheet on Canvas. Hold on. I'm going to share that page. There is a review sheet on Canvas called Final Review Sheet, and it covers the whole semester. Okay. This is what it looks like. And we're going to cover the first 5 topics: introductory materials, licensing requirements, agency, disclosures, and contract law. Okay. I would recommend that you make flashcards for each of the bullet points as a way to study. Okay, to just learn that vocabulary terminology. Everything that comes after contract law, we haven't covered, so don't. This review sheet covers the whole class. I'm just telling you the stuff that you're going to be tested on. Okay, so contract, disclosure, agency, licensing, and introductory materials. Okay, I would also practice the quizzes from the back of the chapters we've covered. Okay, I think that's a great way to prepare for the exam. So what we will do is we will probably go till around 8. Okay, 8 p.m. Then we will take a break, maybe like a 20-minute break or something like that. And then I will open the test. The test will take you 50 minutes, 50 minutes. And I will give you hour and 10 minutes time window in which to take it. Okay. So once you start taking the test, you will only have 50 minutes. But when you start the test, you have a little bit of leeway. Okay. So that's how it'll work. And then if you have any extensions or anything like that, I will take that in. That'll just mean you'll stay a little bit later, and I'll take that into consideration setting up the exam for you. But that's what we'll do next week. We'll finish up contract law, the first half, and then you'll take the exam the second half. Okay. And then I always go over the questions you miss most frequently. So at the beginning of the class in 2 weeks, I will go over the questions you miss most frequently, so you can kind of see like where you might have made mistakes, or, you know, if you want to debate a point with me, that's fine. And maybe I made a mistake, or the answer key was wrong or something like that. We'll do that in 2 weeks. Okay. Yeah. Carmen.
Okay, my question is, we have to study chapters from 1 to
Sorry,
5.
what?
How many chapters we have to study for 1 to 5?
The 5 that I mentioned. The 5
The
that I
5.
mentioned.
Okay,
Yeah.
okay,
Yeah.
that's fine.
And I
Thank
would
you.
study roughly equal time each chapter, more or less.
Okay, but we have to follow whatever is review over here right now.
Well, this is just one thing to review. I would also do the quizzes from each of the chapters that we covered. Right.
Okay.
At the back of every chapter, there are quizzes. So go over the 5 chapters we covered.
Okay.
Right.
Thank you.
Yeah. So why don't we? Yeah, Monica.
We didn't go through the chapter in sequential, right?
Right.
1:15.
Right.
Yeah.
So if you look at the schedule that's posted on Canvas, it'll show you what chapters we've covered up to now. So it's chapters 1, 15, 4, 5, and 6. Yeah, and those are the only chapters you're going to be tested on. And again, spend about 20% of your time on each chapter.
1:15.
What's that? I didn't hear you.
1:15, 4, 5, 6.
Yeah, just look at the schedule and look at the chapters that are covered up until the first midterm. I would also say this. So do the practice quizzes at the back of every chapter, okay? And try to do the quizzes like they're a real test, meaning don't look up the answers and give yourself a minute per question, okay? And that may tell you where you're strong and where you're weak. So maybe Monica like knows the disclosure chapters perfectly, but she got most of the questions about contract law wrong. Then I would say, okay, you need to spend a little more time on contract law than you do the other chapters. Whereas Carmen got all the contract law questions right, but she got most of the disclosure questions wrong on these fake quizzes. Then she should spend more time on chapter 5. So take those quizzes and that'll kind of give you a sense of where you're weak and where you're strong. But when you take the test for real, you will have 1 minute per question. That's it.
Wow.
Okay. And the reason why I do that is because it's to prevent cheating. Because since I'm not with you, this is inherently an open book exam. So to pressure you not to look up the answers, I don't give you much time. Will you have time to look up a few of the answers? Yes. But if you only have a minute per question, you can't keep looking up every answer. You'll just run out of time. So watch your time carefully when you're taking the exam. Don't go too fast. Don't go too slow. Yeah, Carmen?
I have another question, but we're able to, it's an open book quiz?
It's open book, but you're not going to have time to look up the answers.
Yeah, but we're gonna have time to answer a few questions only, right? Because it's 50 questions, right?
But yeah, there'll be a few, you will probably have time to look up a few of the answers. Yes.
Okay.
Also, you should know you can't backtrack. Once you make your answer, that's it. Move on. And you can't go back. Okay. So keep that in mind. And also, the order of the questions and the order of the answers is scrambled differently. So what is number 8 for Carmen might be number 25 for June. So, and that's also to prevent cheating. So you guys aren't calling each other saying, hey, what'd you get for question 8? You know, this is just standard Canvas practice. It's not that I think you guys are untrustworthy or something.
Everyone have different questions.
The order will be different.
Different order. Okay.
Yeah. Okay, Devin?
Just a quick question to put in retrospect. I know you said that it's kind of timed in a sense, but Chapter 5 isn't really going to be covered too much in depth, like you said, correct? Or
no, but it'll be covered. So like you might want to do the
quiz.
Yeah, but I'm not going to go off into the weeds on those questions.
Okay.
Other questions? Okay, so Carmen, do you have another question? You're mute. You're mute, Carmen. Can't hear you. Are there other questions while she's figuring that out? No, nobody else? Yeah, Anne.
As I discussed earlier, I'm not able to take the midterm.
Okay, let's talk after class.
Okay.
Let's talk. It's just not everyone has to stick around for that. Michael.
Is this going to be a multiple choice test?
Yeah, it's multiple choice only. The quiz questions in the back of the chapters are great practice. Any other questions? By the way, don't get heavy test anxiety. These tests are not meant to like fail out people. Usually the vast majority of people pass the test pretty easily. Okay, Monica, and then FOMA.
So you're gonna provide the link to go.
Oh, it's in Canvas. You'll take the exam in Canvas, and we'll go over that in class. I'll show you how it works. But basically, the test will be published, and then it'll show up in Canvas for you, and then you can start it, and then it'll show you one question at a time. Okay, FOMA. FOMA, are you there? Yeah. Question. You're mute. Okay, I'll come back. Carmen, did you have a question?
Yeah, okay. Once again, what chapters, what we have to study?
Okay, just look at the schedule. It's all in writing. And look at the chapters we've covered so far. And that will tell you. Okay. Just
Okay.
look at the schedule.
Okay.
It's spelled out. Okay. AFOMA. Okay. I guess. All right. Anybody else? All right. And I'll stick around with you.
Okay.
All right. Well, then we're done for the night. So again, regular class time at 6:50, and then the exam will be the second half of class. Okay. See you guys next week. Okay. So Anne, you're gonna be gone that day. Remind me.
Yes. Can I come to the campus for at your office hours to take the midterm?
No, you can take it at home. I can just give you early access.
Oh.
So tell me the time you want to, do you want to take it that day or the day before?
I can take any time, but this is my first time online, so is it possible that I can come to your office hour to take the first midterm?
You'd have to bring your own test. I mean, sorry, you'd have to bring your laptop or something. I wouldn't have a computer for you to use.
Oh.
Yeah. If you want, stick around and I can kind of show you what it looks like.
Yes, please.
So why don't you just stick around? Let me handle everybody else.
Okay. Thank you.
Okay, Devin.
Yeah, just a quick question for your student hours. On Monday, are you available to take phone calls instead of in person or on campus?
Yeah. I just need to know. Yeah, if you're calling me during that time, that's totally fine.
Okay.
Yeah.
Okay, cool. Thank you.
And if that time doesn't work for you, you just need to give me a heads up. You're going to call me, but between 12:30 and 1:30, just call. And if I don't pick up, I'm with somebody else or in the bathroom or something. Just leave a message.
Okay, it's nothing. It's just some general questions. I just don't want to write you a book in an email. So.
Okay, yeah, that's fine.
Okay. All right. Thank you.
Okay, sure, Monica.
When is the gym boy?
October 30th.
How do we?
It'll be just regular Zoom class.
Oh, here?
Mm-hmm. He'll be coming to our class that night.
Oh, I see. Okay. So we don't have to sign up for anything.
No. It'll be just the regular class.
Okay. September 30th.
No, October.
Oh, October 30th.
October
Okay.
30th. Yeah.
Thank you.
Michael, is that a question? Okay.
Yeah. Actually, can I talk about this maybe after everyone's leave? This is actually.
Yeah, sure. That's fine.
All right.
Okay. So Anne, okay, let me just hold on. Let me.
Sorry about that.
No, it's fine. Hold on. What I'm gonna do is, give me a second. I need to open up different window. Okay, so you see the class?
Yes.
You see it? Okay. So I'm going to open up another class, not your class, but to show you how the exam would work.
Okay.
Okay. So hold on. So again, this is not your class, but
Okay.
So but the exam process is the same.
Okay.
So do you see where it says Principles of Real Estate Final Exam? Do you see that?
Oh, yes. The
Right
final.
there?
Yes.
Okay. So in your class, it'll show like first midterm. It'll be
Okay.
towards the bottom of your screen. You click on it.
Okay.
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 And then it gives you instructions and it'll give you the exact start and stop time.
Okay.
And so what you need to do is give me a 50-minute window of when you want to take the exam. So it could be, I'm just making this up, 8 p.m. to 8:50 p.m. Monday night of next week.
Where do I enter that?
You email me and tell me.
Oh, okay.
You email me and tell me what time you want to take it, and then I can set this up so it opens just to you for that time. Okay. And then what happens is, so then I'm going to click preview. This will look a little bit different for you because this is the, but basically when it says when you're ready to take the exam, it'll say start quiz. Okay. And it'll give you a little warning. Okay. Once you've submitted an answer, you won't be able to change it later. So you click begin.
Okay.
Okay. And then here it comes.
Oh,
Question
okay.
1. What is not a method to establish a real estate broker? Okay. And then you pick your answer. It
And
will
then-
not, this is just
Okay.
not a question you're going to get, but
Right,
it's just an
right.
example.
Okay.
You pick whatever you think the answer is, and then you click next.
Okay.
You pick whatever the answer is, then you click next.
Okay.
And then at the end, it will tell you the total number you got right and the total number you got wrong.
Oh,
Okay.
okay.
And then I can show you what questions you got wrong the following week. Okay. I can go with you over the questions you got wrong.
Okay.
So just remember, you can't backtrack.
Okay.
Once you make your answer, that's it.
Okay.
I also emphasize the importance of watching your time. So don't spend 5 minutes on a question. You don't have time for that.
Mhm.
What I've also learned working with students is sometimes I emphasize, like, don't be slow, be fast. Sometimes students are so panicked about the time, they go way too fast and they answer 50 questions in 5 minutes, which means they weren't reading them very carefully. This is what I would recommend. I would recommend you set a timer on your phone or whatever. And so like after 5 minutes, you should have answered roughly 5 questions. And if you've already answered 10, you're going too fast. And if you've only answered 1, you're going too slow. So like set timers for yourself every 5 minutes to pace yourself. So you're not going too fast, not going too slow. But that's basically it. Now, if you want to take this, here's an idea. If you want to take this during my office hours sometime next week,
Yes.
I can be on call if you run into a technical glitch. That I could
This is
do.
my first time taking it, so I'm kind of a little bit nervous.
So why don't we do that? So you just need to email me whether you want to take it Monday, Tuesday, or Wednesday at 12:30. And you just I don't need an answer right now. You just need to tell me by like
Okay.
yeah, Monday, Tuesday, or Wednesday. And I can
12:30.
At 12:30. Probably Tuesday or Wednesday would be better. That gives me a little bit more time just to set it up since the weekend is coming.
Okay.
So just tell me which day you want to do it if that time works for you.
Yes.
And then if a problem comes up, you can call me.
Okay.
Okay.
So one more question. So when I finish the 50 questions, do I just click?
And that's it. You're done. And you exit. That's it.
Okay,
Yeah.
I don't have to do anything. Okay.
That's right. Yeah.
Thank you so much. And I'll email you this weekend and to let you know whether it's Tuesday or Wednesday and 12.
Perfect. And then I'll give you its instructions on when it will open. And you will be able to see, once I set it up, you will be able to see on your end, it'll say this will open at 12:30 on Tuesday or whatever.
So if you don't mind, when I emailed you, can you email back says,
Of course.
go to the course and then click
Yes.
here, just kind of a reminder.
Yeah, no. And I'll also confirm when it will start. And I will want you to write me back to confirm that you see it,
Okay.
that you see when it will open up. Okay.
Thank you. I think the first time will be a little harder, but
Yeah,
second time will be
you are not alone, but you'll be fine.
okay. Thank you
Okay.
so much.
Okay, sure. Bye-bye.
Bye-bye.
Okay, Michael, you were next.
Yeah, thank you for being patient. So the thing I was going to mention to you earlier is that I sent the DEPS.
Oh, I already got it.
All right. Just to clarify, I just want to see if you got the accommodations because it was
Yeah, so here's how it will work for you. You will start at the same time everybody else does, but you will get 50 extra minutes. Okay? So like I'll probably start everyone at 8:50. I'm sorry, ignore that. At 8:20. Okay? And the exam is 50 minutes long, which means you will have 100 minutes to do it. And if we start at 8:20, that means you will have till 10. Okay? So
Okay.
that's how it will work. And it should show that when you're taking the exam. And I will explain this to everyone next week. While you guys are taking the exam, I'm sort of watching what's happening. I'm not like out watching TV. So if there was any kind of technical glitch or your accommodation seems to not work or whatever, I can be reached via email. So I'm watching, I'm paying attention. So if there is some breakdown, you can reach out to me.
All right. Perfect. Thank you
Okay.
so much. I
Okay,
was
sure.
just definitely have a great night.
Okay, sure. See you. Talk to you next week.
Definitely.
Bye.
See you next week. Bye bye.